27.
Yes.
Item 27.
Yes.
May plus. The applicant has been convicted under section 302-449 of the IPC and sentenced to RI for life. And he is in custody since 17/2/2006. 17/10/2006. The FIR at page 39.
Yes.
निवेदन कारण ये आम एतलाकारी श्री सिद्धेश्वर पाइकरा PW4 इनफॉर्मल बयस सुआंशु आज को 2 वर्ष है खोर्धा श्रीराम नगर एक घर कर मोर स्त्री प्रवीणा पाइकरा सहित रही आसुची मु खोर्धा महिला विद्यालय किराणी भाव कार्य करे आज ता 16/10/2006 तारीख दिन प्राय दिन 3टा समय मु कॉलेज रे थिबा समय आम साही डिसीज प्रवीणा पाइकरा
Okay.
कॉलेज रे थिबा समय आम साही सौम्यरंजन राउतराय ठारू सौम्यरंजन राउत ही इज द PW5 मैडम सौम्यरंजन राउत ठारू खबर पाइली जे मु रहिबा घर भितरे जने युवक जबरदस्त पसी भीतर पटु कबाट देई अछि ओ घर भितरे मोर स्त्री मध्य रही जाई अछि खबर पाई मु संगे संगे मु घर को आसिली देखिली जे आम्बो घर निकट रे आम्बो साहिर चंद्रशेखर सामल सर्वेश्वर दास
Samola PW2.
yes madam and the
Then
Sarveshwara is the
Sarveshwar Das is PW1.
PW1 madam
Yes. Yes.
Santosh Ranjan Raut is the PW6
Okay.
Mohammad Hanif he has not been examined
Okay.
Manmohan Barik he is the PW9 तथा अन्य बहुत लोक जमा हुई अछंती एही समय खबर पाई खोर्धा थानार पुलिस बाबू माने आसी पहुंचिले और संगे संगे मु तथा भद्र लोक माने मोर घर दांड कबाट भांगी मोर घर भितर पशिलु मु देखिली जे मोर ठाकुर घर भितरे मोर स्त्री प्रवीणा पाइकराय रक्ताक्त होई मरी पड़ी अछि तार बेक गाल इत्यादि हणा हुई गभीर क्षत हुई अछि मोर रोषेई घर और ठाकुर घर रक्तरे जुड़ुबुड़ु हुई अछि मोर ठाकुर घर कोणरे शिवराम भूया आपिलांट गोटे रक्ताक्त कटुरी धरी बसी अछि कौशल क्रमे आमे माने पुलिस सहायता ताकू धरिलु ताकू पचारिबारु से मो स्त्री को हानि मारी देइछि बोली समस्त आगे मानिला शिवराम भूया मु भल भाव जाने कारण से मो पड़िशा घर बासंती साहू घरे भड़ारे रहुथिला आज से मो स्त्री को एकुटिया थिबार देखि मंद उद्देश्य रे मो घरे जबरदस्त पसी भीतर पटु कबाट देइथिला मो स्त्री प्रतिरोध करिबारु से ताकू कटुरी हानि मारी देइ अछि मोर स्त्री रो चित्कार सुनी साईर लोक माने मो घर निकट रे जमा होइथिले तेणु उक्त लिखित एतला विनती अनुरोध करिकि दोषी प्रति कार्यानुष्ठान
Okay. So obviously there would be no eyewitness to the occurrence.
yes
Right? So the main circumstance is that he was last seen. Somebody has seen him
yes
entering
PW9
into the house,
PW9
and he was also found in that house.
yes ma'am
And the presence of the appellant in that house with weapon of offense, which stained with blood, and homicidal death of the deceased. But
apart from that, that room is locked from inside.
okay,
that circumstances have been dealt at paragraph 13 of the judgment
acha, what
what
are
are
the
those circumstances
page number?
page number internal page 10 and running page 12
Running page 12.
page 30
Yes.
paragraph 30 after carefully going through the evidence of the prosecution witnesses and the documents marked as exhibits in this case including the chemical examination report by the exhibit 16 which was given in reply to the forwarding report by the exhibit 15 it is seen that the following circumstances have been relied upon by the prosecution to prove that the accused is the sole author of the crime in question the said circumstances are Romanai, the accused was a tenant in the house of the backside neighbor of the informant. 2, the accused had followed
এই বিষয়ে কি কইছে?
that
Who is the witness to this aspect?
so the was the tenant in the that PW4 informant had stated
PW4.
PW4, but the person in whose house he was staying at tenant, that Basanti
Not
Sahuki has
examined.
not been examined.
But PW4 has stated that.
Yes, ma'am.
Okay.
PW4 and the other one.
Any dispute to that effect in cross-examination?
No.
Cross examination.
So it is not challenged.
A challenge has also, it is not also disputed in the 313 statement.
No, 313 statement, only a specific stand has been given stated by the appellant. Page 37, madam. Page 37 at question number 19. ଯେ ବହୁତ ଲୋକ ସେ ଜାଗାରେ ଥିଲେ, ମୁଁ ମଧ୍ୟ ସେଠି ଥିଲି, ପୋଲିସ ମତେ ଥାନାକୁ ନେଇଗଲା।
जबरदस्ती मोटे दस्खत न लेती है।
Okay, so it is PW4. Next circumstance is?
Next circumstance is the accused had followed Prabina Paikrai, the deceased, while she was returning to her house after collecting water from a tube well.
That was on the date of occurrence.
That is on the date of
Who
occurrence.
has stated that?
PW9. Who had last seen the accused to enter into. Then third is the accused entered into the
Inside the house.
Said house. Inside the house after Prabina Paikrai went there and the door was closed from inside. That was also stated by PW9.
Okay.
The fourth circumstance, neighbors heard the shout of one female from inside the said house.
That has been stated by
PW3 man.
Okay.
And the fifth circumstances is the door of the house of the informant was not opened in spite of call by the persons who had gathered near the said house.
This is by PW?
This is
a circumstance ki koi je?
Yes, PW3.
and
Others may
others also.
PW3 categorically stated.
All right. Next
is immediately after the front side door was forced open by the neighbors in presence of police and the informant, they found the dead body of the deceased were lying in her prayer room of that house, and the accused, who was found sitting in the corner of the said room, was holding one bloodstained cutlery.
So it is a PW4 informant କହିଥିବ ବୋଧେ।
And the PW13, 14.
Okay, next
is immediately at the spot the accused confessed to have followed Prabina Paikrai while she was returning to her house after bringing water from the tube well, and she shouted for help. While resisting the attempt made by the accused to commit rape on her, he committed her murder by means of the cutlery M01 as people gathered outside the said house hearing Allah.
This
confession.
It a confession in presence of the police.
Okay. Presence of the police, and PW9 who was present from the beginning to the end. He has stated that in his presence nothing was stated by the.
All right. Okay.
And the eighth circumstances is the motive of the accused was to eliminate Prabina Paikrai as he failed in his attempt to commit rape on her, and after she had resisted and shouted for help. That is made on the basis of the confession of the accused, and so by the attempt of the rape there is no charge and no conviction has been made, so by the attempt is concerned by the law and trial. And the ninth, the circumstance of multiple external injuries, including one fatal injury, and signs of sexual assault were found by the doctor over the dead body of Prabina Paikrai.
This is doctor is PW?
Doctor is PW11.
PM doctor?
Yes, madam.
Okay.
But this said
we'll come to that. Just
so by the 10th circumstance, the wearing apparatus of the accused was stained with the human blood, and the 11th is the chapel MOV of the accused was found at the spot. XAA, the cutlery MO1 seized from the possession of the accused was found stained with the human blood group O, which tallied with the same human blood group as found in the bloodstained wearing apparatus of the deceased, and with the sample blood collected from the spot. Circumstances have been.
Okay, so let us first go serially. The man who has seen them following the appellant following. So that was PW9. All right.
Page 59.
This witness is a witness not only to the last scene but also about the other aspect.
Yes, ma'am.
Yes.
Okay. Please proceed.
I know the informant Siddheshwar Paikrai. I also know this accused who is present in the dock. On 16/10/2006, the occurrence took place at 2:45 p.m. On the day of occurrence, I was working as a mason in the Hanuman temple situated near the house of informant. I was returning from work to take my lunch. At that time, I saw the wife of informant was going with a gora containing water from towel, and this accused was following her. Wife of the informant entered inside her house. Then accused followed her and also entered into that house. The door was closed from inside. I heard halla of the wife of informant from that house. So I called the Sahi people. The witnesses came in front of the house of informant. We called to open the door, but as the door was not opened, then one of the witness intimated police over mobile phone, and one young man went with motorcycle to call the husband of the informant. On arrival of the informant and police, the door was broken and we entered inside. We found blood marked from the kitchen room to dirty room. We found the dead body of the deceased in that dirty room with bleeding injuries, and this accused was sitting in one corner holding a cutlery. Later, police took this accused to the police station. Cross-examination. I cannot say the name of witnesses who came on hearing my halla. I also cannot name the witness who intimated the police over phone. I also cannot say the name of a young man who went to call the informant. Police stayed about 15 minutes at this spot and thereafter left with the accused in order to avoid breach of peace. I was examined by police. I cannot say whom police examined at the spot as I left the spot. Along with police, about 20 persons entered inside that house. Police examined the dead body at the spot. Police came in a jeep and took this accused in the same jeep. Some police personnel left the spot with accused in that jeep, but I cannot say if any police stayed at the spot. The deceased had injuries, cut and bleeding on her neck, right side, on the head and the left shoulder. All these injuries were bleeding. As I made halla, the witnesses came after 5 minutes. I made halla immediately after accused entered inside the house, and as I had halla of the wife of the informant. In my presence, police did not ask any question to accused. In my presence, accused also did not give any statement to police. After police left, I also left the spot. I cannot say what happened at the spot after I left. I did not know personally the witnesses, but I knew Siddheshwar, the informant. I did not enter inside the house of informant prior to the incident. To my knowledge, informant was staying in that house with his wife. I cannot say if any other person was staying in that house. I saw the deceased prior to the incident once, that is 4 days prior to the occurrence. I cannot say who are the neighbors of the informant. It is not a fact that no such occurrence took place and I am deposing falsehood.
How do you overcome this evidence of this witness who has seen the appellant following the deceased, entering into the house, then the door was locked and immediately there was
Shouting.
shouting from the deceased, and then this man attracted the attention of others. Then perhaps he was she first when she saw the accused closing the door entering into a house, ସେଇ ମୋମେଣ୍ଟରେ ବୋଧେ ସେ ପାଟି କରିଛି ଯାହା ଜଣା
Immediately the halla has come.
ହଁ ତେଣୁ ସେଇ ପାଟି କଲା ପରେ ଇଏ କବାଟ ଆଇଦର ସେତିକି ବେଳେ ବନ୍ଦ କରିଥିବ କି ଜଷ୍ଟ ଇମିଡିଏଟଲି ବନ୍ଦ କରିଛି. Then as it appears she has gone to that kitchen, କାରଣ kitchen ରୁ ଦାଗଟା
Trail
ପଡିଛି.
ଅଛି. Trail of blood is from kitchen to
ତେଣୁ
dirty room.
ପାଣି ଯୋଉ ଗରାଟା ଆଣିଥିଲା ସେଇଟାକୁ most likely
Kitchen ରେ
Kitchen ରେ
ଥୋଇଛି।
ରଖି
କିଚେନ ରଖିବା ପରେ ସେଇଠି ଆରମ୍ଭ ହେଇଛି ଯାହା
Assault, yes.
ଇଏ ଇନସିଡେଣ୍ଟ ହେଇଛି ଏବଂ assault ମଧ୍ୟ ସେଇଠୁ start ହେଇଛି. Then she has gone to that
DT room.
DT room where the final assault was made and the dead body was lying there. Then out of all apprehension he is somehow or other concealing ମାନେ concealing କଣ ସେଇ type ର ସେ room ରେ apprehensive ହେଇ ରହିଛି. ଆଚ୍ଛା ଏଇ ଯୋଉ
Because by then the people have already
Right.
Gathered
in
outside,
the
yes.
gate
at
house
the
to
front
come
of
out.
the house.
maybe that there was no other way to
Yes.
come out of
Escape,
that house.
yes.
Maybe that was the only door for coming out and going
Yes,
into the
yes.
house.
Yes, that has been stated by
IO
No.
PW1.
one.
Inform.
No, PW1 another witness.
All right. So now let us go to that next witness would be the other persons. But before that, let us go to that PM report with the doctor
PW11.
PW11.
because it is a prosecution case that it was a case of sexual assault, then
Yes.
murder, right? All right.
Page 62, man.
Okay.
On 17/10/2006, I was in the same post at Khurda. On that day at 8:30 a.m., I conducted postmortem examination over the dead body of Probina Paikrai, wife of so-and-so, while she was staying at Sriram Nagar, Khurda. During PM examination, I noticed as many as 13 injuries mentioned below on the dead body. All those injuries were antemortem in nature. One
These are all
that
neck, first one, second is the angle of
one is the injury number,
Sir,
one is the
went
fatal
by.
as stated by the letter.
right. Then the right parietal and curved incised wound on the thumb and
Left index finger extending
index.
from
Indiscriminate.
then
That
incised wound.
She might have raised the hand also to save herself.
Definitely.
That is why these injuries
Consciously or
were
unconsciously, because that was the
lacerated.
And
wound.
11, 12, 13 are
Hmm.
consistent blows are there.
Hmm. Okay, what happened on dissection? These were found. Acha, on left side neck muscles, left carotid artery, vein, tracheal rings are incised and caught through the visceral organs so and so.
Cause of death was hemorrhage and shock.
Hemorrhage and shock.
Time of death was within 25 before my PM examination. Signs of sexual assault were present over the dead body.
Cheek also.
Right side.
These teeth marks,
yes, Miller.
as you found, these
11,
are
12, and 13.
11, 12, 13.
that is the sexual assault, right? Okay. All right. Then he examined that MO1, the cautery,
yes,
Yes,
paragraph 2.
and said that it is possible by that MO1.
MO1 and the referring PM examination and all the 13 injuries which I have stated in PM examination report were possible by the sharp side of MO1. I put my signature on MO1 and affixed my seal. MO1 and my query report were taken from me by the police.
Perhaps these are not sharp-cutting weapon injuries. These are the injuries which has been caused by the accused. This 11, 12, 13. These abrasions are also maybe that during fall on the ground he has sustained. Possibility of that weapon cautery re up to maybe 5 ହେଇଥିବ ବାକି ଯଦି ବ୍ଲଣ୍ଡ ସାଇଡ ୟୁଜ ହେଇଥିବ ତାହେଲେ ଏଇ ଯୋଉ ଲାସରେଟେଡ wound ଗୁଡାକ ହେଇଥିବ ଏଗୁଡାକ ଏଇ ବ୍ରୁଇଜେସ୍ ଗୁଡାକ ଏଇ ଯୋଉ ଟିଥ୍ ମାର୍କ ଟା କେମିତି ଆଧିର
Yes.
7, 8 onwards. Up to 6 laceration ହେଇଛି 5 পর্যন্ত সেটা ହେଇଛି incised.
Right. So now the main injury is that neck injury, right? One injury. All right. In cross examination.
It is a fact that paragraph 3. It is a fact that the injuries number 7 to 13 where abrasion and bruises were not caused by MO1,
MO1.
other injuries,
clarified, rightly said.
other injuries of PM examination report were possible by the sharp side of MO1, by MO1 curve type of inside wounds, and also other type of inside wounds are possible. It is a fact that I saw inside wounds of different sizes over the dead body, since force applied at the time of infliction of blows
Yes.
of by MO1 and the direction made at that time were not the same. Inside wounds of different sizes occurred.
Resistance.
By seeing PM examination report, it is not possible to say that from the backside of or front side or from which side blows were dealt individually to cause inside wounds. It is a fact that a bruises and abrasions which I saw were of different sizes. I cannot say who was the author of the teeth marks. It is a fact that injuries by the number 11 and 11 to 13 were of similar size. Injury number 1 was a vital injury and the death occurred due to the said injury. I cannot say which blow was inflicted first. I cannot say which injuries were caused first and which injuries were caused.
Allowed also.
କଣ ଏଗୁଡା କେମିତି allow କରୁଛନ୍ତି? How a doctor would know that which one is? Yes.
Then paragraph 4, MO1 was produced before me 4 days after my PM examination. SI Prahlad Naik produced MO1 before me, but I have not stated so in my query report. My query report speaks that the IO produced MO1 before me. I cannot say if MO1 had contained human blood, but at the time of my examination, it had contained blood-like stains. My query report and PM report do not reveal specifically that injury number 1 was fatal.
Injury number 2.
One is
2 ଲେଖା ହେଇଛି correction ନାହିଁ।
ନାଇଁ ସେ
ଆଇଟା ଅଛି ଉପରେ
ଉପରେ
ବନ୍ଧୁଟା
ଦିଆ ହେଇଛି ଏଇଟା 1 ହେଇକି ଗୋଟେ ଉପରେ ଡଟ୍ ଦିଆ ହେଇଛି।
अच्छा आई
आई रोमान
रोमान आई
ये
आगे 2 ଲେଖା ହେଇଥିଲା ବୋଧେ
भूल
कि आगे आई ଲେଖା ହେଇଥିଲା ତାପରେ 2 କରା
correction କରିଛି ସେ ତ। Yes.
Injury number was fatal and it was not sufficient to cause death. The IO was present at the time when I sealed MO1, but I have not stated his name. The IO has not put his signature on my query report. It is not a fact that I examined MO1 and I submitted my query report in my private capacity and not in my official capacity. It is a fact that the police requisition and my query report do not bear any letter number or endorsement of receipt. It is not a fact that PM examination report and query report are fake documents.
ଏ ଟାଇପ ର ଯୋଉ ଆନ୍ସର ଟା ଦେଇ ଦିଆ ହେଇଗଲା ମିଷ୍ଟର ତ୍ରିପାଠୀ, ଏଗୁଡା ହଉଛି ସବୁ ପବ୍ଲିକ ପ୍ରସିକ୍ୟୁଟର ର ମାନେ ଇନଏଫିସିଏନ୍ସି। ଏଇ ଯୋଉ ଅଲ ଦି 13 ଇଞ୍ଜୁରି, ଆଟଲିଷ୍ଟ ଯଦି ଇଞ୍ଜୁରି ଟା ଦେଖିଥାନ୍ତା ବା ଡାକ୍ତର ବାବୁ ଜଣକ ଯଦି ଆଗରୁ ଟିକେ ଦେଖିଥାନ୍ତେ, ତାହେଲେ ସେ ସାଙ୍ଗେ ସାଙ୍ଗେ ଆସିଥିବ ଡକ୍ ରେ ଚଢିଥିବ ଦେଖାଇ ହଁ ତମେ ଦେଖୁଛ ଯଦି ଏଗୁଡାକ ସବୁ ଏଇ ଟାଇପ ର ଇଞ୍ଜୁରି, କେମିତି ତାକୁ ପଚାରିଲ 13ଟା ଯାକ ଇଞ୍ଜୁରି ପସିବୁଲ ତା ଦେହରେ MO1 ରେ ସାର୍ପ କଟିଂ ୱେପନ ରେ
ସେ ଲିଡ୍ ନ କରିଥିଲେ ଆନ୍ସର କୋଉଠୁ ସେଟା ଆସିବ?
All right, so this is the PM report which at least indicate that number of injuries has been caused on the vital part of the body of the deceased in a sharp cutting weapon which was seized from your possession and sent to the doctor for obtaining his opinion. And the prosecution case that may be on account of sexual assault, the deceased protested, and that is the reason for which this assault was made. There are some injuries found on the body of the deceased which suggest that there has been sexual assault. So this is the evidence of PW11, the doctor who conducted PM. Okay, now the rest of the person are the persons who broke open the door, entered inside, and must have stated about the confession.
Yes, sir.
Right? Let us go one by one, just read it.
PW1.
Yeah.
PW1, page 39. I know the informant. I also know the accused. I know the deceased Probina Paikrai. On 16/10/2006, at about 3 p.m., hearing halla, I went to the house of informant. Santosh Raut, Mohammad Hamid, and Chandrasekhar Samal also came there. We went there hearing the halla of Manmohan Barik. The informant
Manmohan Barik by
is
PW9.
PW9.
Okay.
The informant was not present in his house. We found the entrance door of his house was shut from inside. We were hearing halla of a woman from that house. Witness Prabhat Mishra intimated the police over telephone. That Prabhat Mishra is PW3. He also sent son of Santosh Raut to call the informant who was working in the women's college Khurda. The informant as well as police came. The entrance door was broken in presence of police, and we entered inside and found the deceased lying dead in the prayer room, and fresh blood was spreading from the kitchen up to that room. This accused was sitting inside that prayer room holding a koturi. The said koturi was stained with blood. The deceased was inflicted with injury on her right hand, index finger, right breast, left side neck, below ear, and head. Her bangles were lying scattered, being broken there. Being asked by us, accused told that while the deceased was bringing water from the tube to her house, he followed her and closed the door, and when he attempted to commit rape, she
So
shouted.
another thing that when this PW9 saw the appellant following the deceased and entering into the house, he has not stated to have seen any weapon in the hands of the appellant.
Yes, not.
Right. So that cutlery was perhaps there in that house somewhere. Okay.
And
Yes, next continue.
In my paragraph 3, in my presence, police made inquest over the dead body and prepared the inquest report on which I signed. This is the inquest report marked Exhibit 1, and this is my signature marked Exhibit 1 by 1. Cross-examination. Besides kitchen room, there are 2 rooms in that house. After the entrance door, there is a veranda, and then there is a kitchen room, and by the side of that veranda, 2 other rooms are there. From the entrance door, one has to pass in front of those rooms to reach kitchen room. After the entrance door, the first room on the right of the veranda is the prayer room where the dead body was lying and accused was found sitting. Being called by Manmohan Barik, I went to the house of the informant. By the time I reached there, Manmohan Barik as well as another person was present outside of the house, but I cannot say his name. We waited for about 15 minutes at the spot, that is the house, till the arrival of police, but we did not try to enter inside the house through the backside. There was no backside door of that house.
This is important.
As Prabhat Mishra intimated police as well as informant, I personally did not intimate to police. My house is at a distance of 25 feet from the house of informant, intervened by 3 other houses belonging to Basu Mishra, Bhagirathi Mishra, and Hutananda Hutta. They were also present at the spot. That is in front of the house of informant. I signed the inquest report at the spot. I was also examined by police at the spot. It is not a fact that the accused did not confess that he murdered the deceased and that he was not found at the spot holding cutlery. And PW2.
Yeah.
I know the informant. I know the accused standing in the dock. I also know the deceased Probina, wife of informant. On 16/10/2006, the occurrence took place. On that day at about 2:30 p.m., Manmohan Barik, a mason, shouted. So I went in front of the house of informant. The entrance door was shut from inside.
Manmohan is PW9, right?
PW9, yes. From inside, and we had halla of a woman. One Mishra Bhaina, namely Prabhat Mishra, intimated police over telephone. He had also sent son of Santosh Kumar Raut, namely Pinna, to call the informant. Police as well as informant thereafter came. Thereafter, in presence of police, the entrance door was broken and we entered inside. We found the deceased lying on the floor of Thakura prayer room with bleeding injuries on left side neck, her head, right side index finger, and the right side breast, right neck. We also found this accused Sivaram Bhuya inside that room. Police told him the accused was holding a koturi stained with blood. The blood was spreading from the floor of kitchen up to the prayer room. Being asked by police, accused admitted to have followed the deceased and entered inside her house and caught her in order to commit rape. And as the deceased shouted for help and people gathered in front of the house, in panic, he committed murder of the deceased with that koturi. In my presence, police made inquest over the dead body and prepared the inquest report on which I signed. This is the inquest report, Exhibit 1, already marked, and this is my signature marked as Exhibit 1/2. The cross-examination. Santosh Raut, Prabhat Mishra, Sarveshwar Das, and others, about 10 to 15 persons, gathered in front of the house of informant. No woman entered inside the house with us. 10 to 15 minutes after, police as well as informant came. There are two rooms in that house and the kitchen is made on the veranda. After the entrance door, there is a veranda leading to kitchen room, and by the side of veranda there are two rooms. One has to pass on the veranda in front of those two rooms to reach kitchen. The first room is made as prayer room or DT room. By the time we saw, the deceased had already expired. Her head was to the waist and the entire wearing dress and body were with blood. I was examined by police at the spot. Police also examined some other witnesses. It is not a fact that accused did not confess to have murdered the deceased with koturi and that I am deposing falsehood.
Okay, next.
PW3, the person who has sent the information first to the police, my lord.
Police, right.
I know the informant. I know the accused standing in the dock. I also know the deceased Probina Paikra, wife of the complainant. On 16/10/2006 at about 2:45 p.m., the occurrence took place. I was in my house at Sriram Nagar. Khurda. Manmohan Barik was shouting on the road in front of the house of complainant. Hearing his shout, I went there. At that time, along with Manmohan Barik, Sarveshwar Das, Santosh Ranjan Rao, Chandrasekhar Samal, Mohammad Anif were present there. They told me that somebody has entered inside the house of complainant and there was halla inside. We found the door of the complainant's house was closed from inside, and as we knocked, nobody replied and opened the door. Then I sent Soumya Ranjan Rao to call Siddheshwar Paikrai, the owner of that house, who was serving in the Women's College, Khorda. I also intimated the Khorda police over telephone. At about 3:10 p.m., both police as well as complainant Siddheshwar reached. In presence of police, we broke open the entrance door of that house and entered inside. We marked blood spreading from the kitchen room to the prayer room. We found the deceased Probina lying in that prayer room, dead within a pool of blood. She had bleeding injuries on her head, neck, cheek, right hand, index finger. In the corner of that prayer room, we found this accused was standing, sitting, holding a koturi in his hand, and that koturi was stained with blood. Accused had put on a black color pant and a sporting banyan of white and blue color. Being asked, accused confessed that while the deceased came to her house bringing water, he followed her up to her house, closed the entrance door from inside, and attempted to commit rape on her. And when the deceased shouted for help, and when he became unsuccessful to commit rape, he murdered her by koturi. In my presence, Police Babu seized broken bangles, piece of broken silver chain, and golden ear flower from spot. Police also seized the blood-stained koturi from accused in my presence. Police prepared the seizure list. Police also seized gauze cloth soaked with blood from the spot. This is the seizure list in respect of koturi marked as Exhibit 2, and this is my signature marked as Exhibit 2/1. This is the seizure list in respect of gauze cloth soaked with blood and broken bangles marked Exhibit 3, and this is my signature marked Exhibit 3/1. This is the seizure list in respect of seizure of plastic chapel from the entrance of the house of complainant marked Exhibit 4, and this is my signature marked Exhibit 4/1. Later, police also seized the black collar full pant and the sporting banyan of the accused stained with blood at PS and prepared the seizure list on which I signed. This is the said seizure list marked Exhibit 5 and this is my signature marked Exhibit 5/1. Cross-examination. Police came to spot after receipt of my telephonic message and started investigation. Police examined me and other witnesses at the spot. Santosh Kumar Raut is the other witness of the seizures made in my presence. Police collected blood from the spot by means of gauze cloth and seized the same. By the time I reached the spot, other witnesses whom I named earlier had already came there. Police and complainant came to spot almost at the same time. I, along with other witnesses, broke open that entrance door in presence of police. Then first police, IAC NC Sethi, SI Prahlad Naik, ASI Bipin Sethi, and Habildar entered, followed by us. After the entrance door, there is the prayer room and then the bedroom, and the last one is the kitchen. I did not go inside the bedroom. I cannot say if other witnesses entered inside the bedroom. The kitchen room is just in front of the entrance door and in between there is a veranda. The kitchen room is at a distance of 20 feet from the entrance door. By the side of veranda, the bedroom and prayer room situate. The entrance door faces to the north and the kitchen situates on its south. In between kitchen and entrance door, those two rooms adjoins the veranda to the west. There were footprints on the blood spreading from kitchen to prayer room, but I have not counted those footprints.
Mr. Divedi,
Yes.
we find that you have already placed, it is almost identical.
Almost identical. Yes,
So
sir.
better you come to the IO's evidence, because almost all the witnesses have stated like this.
The affair, one thing is
Bit by
the
bit and minute.
affair which was lodged by the in the affair at page 30, Lordship, that is endorsement is that it was lodged at about 3:30 p.m. The informant who is PW4, he stated that he lodged the FIR at 8 p.m. at the police station.
But as it appears, you come to the IO's evidence.
Yes, ma'am.
That will
PW30.
clarify the position.
Yes, ma'am.
Actually, how the FIR was lost and which place it was lost. So this come to page number 69.
16, yes, ma'am.
Yes.
On 16/10/2006, I was PW13 is the IAC.
Right.
IO is
He is
PW.
he is
Yes,
also the investigating
Yes.
officer. Yes.
I was IAC at Khurda PS. On that day at 3 p.m., I received a telephonic message from Prabhat Kumar Mishra.
That is PW3.
Yes, ma'am.
Yeah.
That a man, by entering into the house of Siddheshwar Paikrai, had closed the door from inside. I made stationary entry and proceeded to the spot along with SI, ASI and Habildar. At the spot, I found that the house of Siddheshwar Paikrai was closed from inside and many people, including Prabhat Mishra, were present at the spot. Siddheshwar Paikrai reached there with their assistance. I broke open the door of Siddheshwar Paikrai. I entered inside the house and found that the dead body of Prabina Paikrai was lying with bleeding injuries on the face and other parts inside the DT room. There were bloodstains indicating dragging mark of the deceased from the kitchen to the DT room. Her silver chain was lying broken there. The dead body was lying half naked. The accused Shivaram Bhuiya was found sitting in a corner near the door of the DT room holding a blood-stained cutlery. He was trying to conceal his presence and he was in a puzzled mood at that time. We managed to catch hold of the accused. Siddheshwar Paikrai presented a written report before me at the spot at about 3:30 p.m.
Yeah.
I treated it as a affair and directed S.I. Prahlad Naik to investigate into the case. I sent it to the PS for registration. Exhibit 6/2 is my endorsement with a signature on the affair. Exhibit 6/3 is the endorsement with signature of Asmita Paramita. SI of Khurda PS regarding registration of PS case. The accused, after he was caught by us, confessed to have committed murder of Pravina Paikrai inside the spot house. In order to avoid breach of peace, I brought the accused from the spot to the PS. The IO conducted investigation, held inquest over the dead body, and seized the weapon of offense and other material objects. Photos were taken at the spot. Before proceeding to the spot, I made entry number 418 in the station diary of the PS, but I have not inflicted station diary entry number in my endorsement of the FIR by the exhibit 6.
Reflected or inflicted?
Yes, ma'am. Indicate. Exhibit 6/2 because the FIR was received at the spot. Since it was not necessary, I did not mention station diary entry number in Exhibit 6/2. Extract of the said station diary entry is not now available in the record. I do not remember at what time the IO reached. The IO recorded my statement on 16/10/2006. I remained at the spot for 1 or 2 hours on 16/10/2006. It is a fact that I had not received FIR by the time I entered inside the house and saw the dead body and caught hold of the accused. I cannot say what sort of preliminary investigation the IO undertook either at the spot or after the spot. The accused and I myself were present at the spot before the IO. When the IO was continuing his investigation, I do not remember if the statement of the accused was recorded by the IO in my presence. It is not a fact that I did not state to the IO that the accused on my question confessed to have committed murder of Pravina Paikrai. The IO had consulted with me from time to time regarding progress of the investigation. I did not advise the IO to record confessional statement of accused. I cannot say boundary of house of Siddheshwar Paikrai, Prabhat Mishra, Sarveshwar Das, Santosh Ranjan Raut and others were present with me when the accused confessed his guilt. I do not remember if I did not state to the IO that the accused was in puzzled mood when he was found sitting in a corner of duty room. It is a fact that except sending the FIR through Havildar to the police station for registration, I did not take up any part of investigation because at the spot I directed SIP Knight to conduct the investigation. It is not a fact that the accused made no statement before me and witnesses.
Okay. Another IO is the PW14.
On page 72. On 16/10/2006, I was SI of police at Khurda police station. On that day at 3 p.m., IIC NC Sethi received a telephonic message from one Prabhat Mishra of Sriramnagar Khurda that one unknown person has forcibly entered into the house of one Siddheshwar Paikrai in order to commit crime and close the door from inside. Some outsiders guarded the house. On getting intimation, IIC Shri NC Sethi, myself, and ASI BB Sethi, Havildar Dolagobindo Mahali left the police station to verify the matter after entering in SD number 418 dated 16/10/2006. On arrival at Sriramnagar at the spot house of Siddheshwar Paikrai, we found huge gathering near his house and the house was closed from inside. Witnesses Manmohan Barik, Chandrasekhar Samal, Sarveshwar Das, Santosh Ranjan Raut, Mohammad Hanif, and Prabhat Kumar Mishra, along with Siddheshwar Paikrai, were present there. On arrival of police, IIC, myself, ASI, and other witnesses, and Siddheshwar Paikrai entered inside the house by breaking the front door, and found the wife of Siddheshwar Paikrai, namely Praveen Paikrai, lying dead inside his worshipped house with multiple bleeding injury on her person, and accused Shivaram Bhuya sitting on the corner of the said room holding a kotari stained with blood. He was caught red-handed. Siddheshwar Paikrai, husband of the deceased Pravina Paikrai, presented a written report to the IIC Khurda PS at the spot at 3:30 p.m. On the same day, to which IIC treated as FIR under section 449/302 IPC and directed me to take to investigate into the case and send the report to police station through Havildar Dolagovinda Mahali for registration of the case.
So, Mr. Dwivedi,
Yes.
what you are pointing out that we have verified that, of course, the informant has stated that he lost the FIR at 8 o'clock in the cross-examination. But these two evidence of these two police officers,
Yes.
and coupled with the document itself, that
Yes.
FIR itself, that indicates that how it was when it was received and when it was registered. So the document corroborates the version of these two investigating officers that it was received at 3:30 p.m. and then it was sent to the police station, and ultimately the FIR was registered. The registration timing has also been given there. So might have he has also stated, of course, he has stated
that was
that
not the state of mind of the witness that we can expect with
so
precision. He can say.
moreover, merely because he has stated if other evidence are acceptable, যে টাইমিংটা ভুল କହିଦବା ମାନେ ନୁହେଁ ଯେ entire prosecution case କୁ ଇଏ ହେଇଯିବ. So how do you say that one thing may be that when there is no evidence that you are armed with the
entered into the house armed with any
so
weapon.
initial stage there might not have been any intention to murder that lady.
Yes.
The intention was to commit sexual assault. So when there was resistance to that, some attempts were made, but there was resistance, every possibility of getting a cautery from somewhere from there and then assaulting. But whether you entered into the house with cautery or you got that cautery inside the house is hardly matters because of these circumstances which are there. Sexual assault has been made, murder has been made, and your presence there, weapon was there, and it indicates that the deceased was first assaulted inside the kitchen itself. Then she perhaps ran to save her life, entered into that deity's room where she was finally assaulted and died, and you were also found present in that room.
No, but dragging mark is there.
Drag.
So she has been dragged to the DT room also.
Uh,
Trail of blood is there.
trail of blood is dragging mark.
Dragging will
Dragging
mark
mark
is
is
अच्छा फूड की
PW
one.
ये से फर्स्ट जीतले फर्स्ट आईओ आईआईसी
Yes.
PW
13 will.
13
maybe that while assaulting ସେ ଯଦି ପଡି ଯାଇଥିବ ସେଇ ଅବସ୍ଥାରେ ଘୁଷୁଡି ଘୁଷୁଡି ଯାଇଥିବ ଯଦି ଠାକୁର ଘରକୁ ସେଇ
there is blood stain indicating dragging mark of the deceased from kitchen to the DT.
କିଚେନ ରୁ ଯାଇଛି ତ
That is all along. That is consistent.
ଫାଇନାଲ
ଟା ଆସିଛି
ଆସିଛି ଡିଟି ରୁମ୍ ଏବଂ ସେଇଠି ହିଁ ଡେଡ ବଡି ମିଳିଲା ସେଇଠି ପୁଲ ଅଫ ବ୍ଲଡ ମିଳିଲା ସେଇଠି ପ୍ରେଜେନ୍ସ ମିଳିଲା ଆପେଲାଣ୍ଟର ୱିଥ ଦି ୱେପନ ଅଫ ଅଫେନ୍ସ ତେଣୁ and most important thing is that the door was locked from inside. That was broke open. That is also not only stated by the police personnel but also all the independent witnesses, including of course the informant. All of them have stated that the door was broke open, and this accused was having no other way out because she could not have come out because she knew that they are almost surrounded the house and there is no other way out except that door. That is the evidence of
In cross examination they brought that there is no door
no
except the entrance door.
Yes, and the scenario is such that we cannot also expect that the people who had gathered in front of the house would not have shouted bahar be bahar. So all these panic things, he cannot come out.
Sport house रे आपको door भी थिले
House
entering any other person.
house of
से देखେଇଛି ହାଉସ୍ ଅଫ୍ କମ୍ପ୍ଲେନାଣ୍ଟସ୍ ମାଂସ ନାଇଁ ଏ ଯୋଉ ସ୍ପଟ୍ ହଉଛି ଏଇଟା ମାନେ ଯୋଉଠି ଡେଡ୍ ବଡି ଟା ପଡିଥିଲା ପେଜ ସେଟା ହଉଛି ରନିଂ ପେଜ ବୋଧେ 88 of the paper book
88.
ହଁ
88
ସେ ଡେଡ୍ ବଡି ଟା ଯୋଉ ପୋଜିସନ ରେ ପଡିଥିଲା ସେଟାକୁ ଦେଖେଇଛି ସ୍ପଟ୍ ରେ ସୋ ତାମାନେ ଏଇଟା ଗାଁ ରାସ୍ତାଟା ହଉଛି ଏଇଟା ଯୋଉ ରୋଡ ଟା
ଆଜ୍ଞା
ରୋଡ ରୁ ତାପରେ ସିଏ
ଟ୍ୟୁବୱେଲ ଦେଖିଛି
ଟ୍ୟୁବୱେଲ ଟା କୁଆଡେ ଗଲା
ଏଇଟା ଏଇଠି ଜି ରେ
ଆଚ୍ଛା ଆଚ୍ଛା ଆଚ୍ଛା
ଏଇଠୁ ତା ଘରକୁ ସେ ଯାଇଛି ସୋ ଫଲୋଇଙ୍ଗ ଇଜ ଦେୟାର
ହଁ ହଁ ଏପଟେ ଆସିକିନି ଦେନ୍ ତାର ଏଟା କଣ ହାଉସ୍ ଅଫ୍ ସ୍ୱାନ୍ସୋ ଆଚ୍ଛା ବି ଟା ହଉଛି ହାଉସ୍ ଅଫ୍ ସ୍ୱାନ୍ସୋ ବି ବାସୁଦେବ ମିଶ୍ର ତାମାନେ ଏ ଲୋକଟାର ନାଁ ହେଲା
ସିଦ୍ଧେଶ୍ୱର
ସିଦ୍ଧେଶ୍ଵର ହଁ ତାମାନେ ଏ ଆଚ୍ଛା
ଏ ରେ ଏଣ୍ଟ୍ରି ହେଲା
ହଁ ଏ ପଟୁ ଯୋଉ ଗାରଟା ଦିଆହେଇଛି ଯୋଉଟା ଦିଆହେଇଛି ସେଗୁଟା ହଉଛି ଡୋର ତାମାନେ
ଡୋରଟା
ଦିସ୍ ୱାନ୍ ଇଜ ଦି ଡୋର ହେଲା ଏଲ୍ ଆଣ୍ଡ ବି କଣ ଦେଖେଇଛି ଏଲ୍ ବି କଣ ତା ଭିତରେ ଗୋଟେ
ସେ
ଲେଖିନି
ଦେଖୁଛି ଭିତରେ କେ ଇଜ କିଚେନ
କେଟା
ବି ଇଜ ବେଡରୁମ
କେ ଇଜ କିଚେନ ବି ଇଜ ବେଡରୁମ
ଆଉ
ଡବ୍ଲୁ ଲେଖା ହେଇଛି ସେଟା
ଆଚ୍ଛା ଆଚ୍ଛା ଓ ଏଠି ଲେଖା ହେଇଛି ବି ହଉଛି ବେଡରୁମ କେ ହଉଛି କିଛି ଡବ୍ଲୁ ହଉଛି ଓରସିପ ରୁମ
worship room।
ରାଇଟ ଓ ଏଠି ଗୋଟେ କଣ ଏକ୍ସଟ୍ରା ବି ଲେଖା ହେଇଯାଇଛି ଏଇ ଯୋଉ ଏଇ ଗୋଟା ତ ବି ଟା ହଉଛି ବାସୁଦେବ ମିଶ୍ରର ଘର ତା ଭିତରେ ଗୋଟେ କଣ ବି ଲେଖିଦେଇଛି ବଟ୍ ଏଇଟା ହଉଛି ପୋଜିସନ
ସ୍ପଟ ରେ ଏଠି ପଡିଛି
ତାମାନେ ଏଠୁ ଯାଇକିନି ଏଇ ଯୋଉ ବାଟ ଦେଇକିନି ଏଠୁ ଏଇଟା ବାରାଣ୍ଡା ଭଳିଆ ବୋଧେ ଅଛି ଏଠି କିଚେନ କୁ ଯାଇଛି then
ଷ୍ଟ୍ରେଟ ହେଲା କିଚେନ
ହଁ
ଦୁଇଟାକୁ ଯାଇକି ତାପରେ
then
ଫାର୍ଷ୍ଟ ରୁମ ରେ ପଡିଥିଲା ନେକ୍ସଟ ବେଡ
and postmortem report indicates the cautery was having human blood in page number 85 running page human blood and group also has been given to be O which is of course the maybe that blood of that lady because
Deceased.
her blood was lying at the spot from there it was
They have taken,
collected
right.
okay and
judgment paragraph 20 ଅଛି that of course as per the chemical examination report exhibit 16 no opinion could be given to come to conclusion that said blood was human blood
କୋଉଟା କହିଲେ
judgment ରେ page running page 22
ନାଇଁ କଣ କୋଉଟା
in banyan
ଏଇଠି judgment ରେ ଟିକେ ଲେଖିଛନ୍ତି
that is with regard to the pulpit and banyan
ବାନିୟନ ମାନେ accused ର you are right
ଏଇ
that is
ଦିଟା
ଆଇଜେ ହିସାବରେ ମାର୍କ ହେଇଛି ବ୍ଲଡ ଦେଖା ହେଇଛି ବଟ୍
କଟୁରୀରେ ଅଛି କିନ୍ତୁ ଏଇଟାରେ ନାହିଁ ଇନକନକ୍ଲୁସିଭ ହେଇଛି ଡିଟେରିଏଟେଡ ହେଇଥିବ
house trespass 449 is also attracted house trespass in order to commit offense punishable with death and
what is always told is extracting the sample blood is very important.
Yes.
Normally we have a notion that if blood is fresh, probably that will give the best result. No, a dried blood is always taken because the fresh blood gets deteriorated. So fresh blood thila seiti niya hichi.
so what is yours ultimately we have almost gone through the entire case what are your any points where you want to one you said that the timing of lodging of the FIR is discrepant vis-a-vis PW4 and PW13 and so any other point
he is the residence of my lord the district Ganjam
Who is the resident?
the appellant. The occurrence was occurred at the Khurda. The tenancy he was staying. Basanti sir has not been examined. How could you room night escape?
सी एग्जामिन करनाली एटा कोन हो सी ता घरे रहउतला पळेला तापरे ताको आसी सी तो सेते बेले सेठी बडा रे रहउतला ना सी आगुरु at one point of time he was staying as tenant. That is, I think, evidence of
He was
wife of से कहउतला ना in front of से कोडी उडे कहि जी जे ये आगुरु रहउतला बेली बासंती घरे बेली
Basanti Sahu.
हां सेटा की कहि जे
PW4 कहि
4
Sir nije inform.
देखेले से लाइन टा कोडी
Thank
से is the informant in this case. Okay. See, एथरे तो कहि छी हमर बोधे FIR से विषय
paragraph 7 page 49
for page
49
49.
yes page
Yeah.
49 paragraph 7 at the 6th line. Accused was staying on rent in the house of one Basanti Sahu at the backside of my house. I did not find Basanti Sahu in front of my house on the day of occurrence. The paragraph 8 रे कहउछन्ति जे it is not a fact that the accused was not staying in the house of Basanti on rent. I do not know if this accused filed a case against a homeopathic doctor on the allegation that he misbehaved his wife. I heard about such an incident that a homeopathic doctor misbehaved a woman at Khurda. I do not know if this.
So how is it relevant to this case? If at all we expect this.
कौन तार माने कौन
Police ता
accused has filed a case against a homeopathy doctor on the allegation that he misbehaved his wife. माने homeopathy doctor ता accused स्त्री को खराब व्यवहार करथला बेली सी उटे केस फाइल
से पुलिस को सेठी अब्यूज करथला सेठी में पुलिस ता केस रे ट्रैक करछन. I do not know if this accused abused police people at Khurda for which he was arrested and for this.
Yes, Mr. Tripathi, what do you say?
Another thing, he was taken a stance in 313. That is not, he was asked in cross-examination anywhere.
What stand he has taken?
बहुत लोक से जगह रे जमा थिले मु मध्य सेठी थिली पुलिस मते थाना को नहीं गला.
No, police didn't keep that accused for longer period because they apprehended that there would be
breach of peace
and
it's a proper action. We can
say that they were quite justified in taking that. Otherwise, loko बहुत समय ए type of situation एला माने they take law into their own hands.
सेटा mob lynch हे जान.
ये लोकोडी बेल अछि ना भीतर अछि.
Rather one part of the statement, if you take it further reinforces the presence of the accused at that spot.
Yes.
मु सेठी थिली. पुलिस माने थाना को नहीं गले बहुत लोग. So
he's in custody since 2006 17/10/2006.
The timing, you see, the timing he has selected because he knew that at this point of time nobody would be there, so I would be perhaps successful in my mission. That is how weapon से नहीं की जाएगी. अलगा उद्देश्य रे से जाइछि. ये जेतेबेले बसिछि फटकिन डोर टा बंद करी ये पार्टी कला परे तापरे जेतेबेले अटेम्प्ट करी ये फास जाइछि जो ये सेठी सेक्सुअल असॉल्ट हला परे रेजिस्टेंस हला परे आ किछि सेतेबेले पार्टी तुंड ऑलरेडी सुनी लोक गदाई गेलन सेतेबेले गदाई गेलन आ किछि उपाय किछि नै. So then assault start. that has and ये जो circum जो ଗୋଟେ say man may lie circumstances do not तो ये जो circumstance गुड़ा ଗୋଟେ रही जाइए गुड़ा पूरा complete chain form कर दूँ Alright. JCRL number 76 of 2008. The appellant Sivaram Bhuiya faced trial in the court of an ad hoc additional session judge FTC Khurda in ST case number 20/52 of 2007 for offences punishable under section 449 and 302 of the Indian Penal Code on the accusation that on 16/10/2006 at about 2:45 p.m. at Siramnagar, Khurda, he committed house trespass by entering into the building of Siddheswar Paikrai, bracket PW4, which was used as human dwelling, and committed murder of his wife Probina Paikrai, bracket hereafter the deceased. The London Trial Court by judgment and order dated 18/9/2008 found the appellant guilty of both the charges and sentenced him to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000 in default to undergo rigorous imprisonment for 5 months under section 302 of the Indian Penal Code. However, no separate sentence was imposed for the offence under section 449 of the Indian Penal Code. The prosecution case, as per the first information report, bracket exhibit 6, lost by Siddheswar Paikrai, bracket PW4, before the inspector in charge of Khurda police station on 16/10/2006 is that he was living with the deceased since 2 years prior to the date of occurrence in Siramnagar, Khurda, constructing a house there. And he was serving as a clerk in the Women's College, Khurda. On 16/10/2006 at about 3 p.m., while he was present in his college, he received message from Soumyaranjan Raut, bracket PW5, that one person had entered into his, bracket like the PW4's house forcibly, and the deceased was was also present inside the house. Receiving such message from PW5, PW4 immediately rushed to his house and found that the persons of the locality, that is Sarveshwar Das PW1, Chandrasekhar Samal PW2, Santosh Ranjan Raut PW6, Manmohan Barik PW9, and others have congregated there and the police, Khurda police, also arrived at the scene of occurrence, and the front door of the house of the informant was broke open, and the informant noticed that the deceased was lying dead with bleeding injuries in the deity's room, and there are injuries on the neck and face, cut injuries, and there are also blood stain in the uh, kitchen and also in the deity's room. And in a corner of the deity's room, the appellant was sitting holding a blood-stained Qatari. With the help of the police, the appellant was captured, and he confessed before police and others that he had killed the deceased. It is further stated in the first information report that the informant knew the appellant very well, as he was staying on rent in the house of the neighbor of the informant, namely Bashanti Sahu. It is further stated that finding the deceased alone, the appellant entered into the house and closed the door. And since the deceased protested to the act of the appellant killed her by a cautery. Hearing the shout of the deceased, the people of the locality had congregated at the spot. On the basis of such, on receipt of the written report at the spot from PW 4, the inspector in charge of Khurda police station, namely Nimai Charan Sethi, bracketed PW 13, who had come to the spot on receiving telephonic message from PW3 Prabhat Chandra Misra, and after making a station diary entry, sent the report for registration, and accordingly Khurda PS case number 370 of 2006 was registered under section 449-302 of the Indian Penal Code against the appellant. PW 13 was already at the spot and apprehended the appellant from inside the house of the PW 4. Brought the appellant to the police station, and investigation, he entrusted the investigation to PW 14 Prahlad Nayak, the SI of police attached to Khurda police station, who had also accompanied PW 13 to the spot. after receiving the communication telephonic message from PW3. The PW14 during course of investigation examined the informant and witnesses, prepared the spot map, Exhibit 12, arrested the appellant, seized the cautery stained with blood from the possession of the appellant as per seizure list Exhibit 2. The photograph of the dead body of the deceased was taken with the help of one photographer. Inquest over the dead body was conducted and inquest report Exhibit 1 was prepared. In presence of the witnesses, the dead body was dispatched to District Headquarters Hospital, Khurda, for postmortem examination through constable, and thereafter PW14, the IO also seized the pair of sky-colored plastic chappal of the appellant, which was kept at the staircase of the house as per seizure list Exhibit 4. He also seized the wearing apparels of the appellant stained with blood as per seizure list Exhibit 5. The seized articles were kept in PS Malkhana. The sample blood in gauze cloth were collected from the spot along with some broken bangles having stained with blood of the deceased and were seized as per seizure list Exhibit 3. The appellant was sent to DHS Khurda for his medical examination and collection of nail clippings and blood grouping. And after his medical examination on production of by the Havildar, those were seized as per seizure list Exhibit 8, and the appellant was forwarded to court on 17/10/2006. The wearing apparels of the deceased were also seized, and the as per seizure list Exhibit 7, after it was produced after the autopsy was conducted by the constable as per seizure list Exhibit 7. The PW14 also received the color photographs of the deceased, and on 20/10/2006 he also received the PM report of the deceased. The cautery which was seized from the possession of the appellant was sent to the doctor for his opinion, and the seized exhibits were sent to SFSL Rasulgarh through SDGM, London SDGM Khurda for examination and opinion, and the C report was also received, and on completion of investigation, charge sheet was submitted. C report C receipt পরে C report আচ্ছা 30/12/2006 টা কেবে গেল নাই তার C report কাটি দিই on completion of investigation charge sheet was submitted. The defense plea is one of denial, and it is stated that at the spot, number of persons had congregated, and he was also present at the spot, and the police took him to the police station, and he has been falsely entangled in the case. In order to prove its case, the prosecution examined 15 witnesses, exhibits would have. Prosecution also proved 7 material objects would have. The Lennon trial court, after assessing the oral as well as documentary evidence, enumerated the circumstances which are appearing in this case against the appellant in paragraph 13 number 13 of the impugned judgment, which are as follows. Quote kar diya. The London trial court, after discussing the evidence of the doctor and the postmortem report, came to hold that it has been proved beyond reasonable doubt that death of the deceased was a homicidal one. However, it was held that there are no direct evidence in this case. But laid down the circumstances. But the case is based on circumstantial evidence, and then enumerated the circumstances in paragraph number 13 of the impugned judgment, which are as follows. The London trial court, after discussing the evidence on record for each of the circumstance, found that this prosecution has been able to prove the case beyond all reasonable doubt that the appellant had committed the murder of the deceased. The accordingly found the appellant guilty under the offences charged. Mr. Suryakant Dwivedi, learned counsel appearing for the appellant, argued that though according to the inspector in charge of Khordha police station, the written report was presented by PW4 at the spot at about 3:30 p.m., which was treated as FIR. But PW4 in his cross-examination has stated that he lost the report at 8 p.m. The London counsel further argued that though it is the case of the informant that the appellant was staying on rent in the house of one Basanti Sahu, which situates at the backside of his house, but Basanti Sahu has not been examined in this case. It is submitted that the circumstances are not clinching and they do not form a complete chain, and therefore it cannot be said that the finding arrived at by the London trial court in convicting the appellant under the offense charge is justified. Therefore, benefit of doubt should be extended in favor of the appellant. Mr. Tripathi Lanen, counsel for the state, on the other hand, supported the impugned judgment and argued that the circumstances which are enumerated by the Lanen trial court in paragraph number 13 of the judgment, when vividly described, analyzed, and the evidence on record has been properly assessed by the Lanen trial court, and the circumstances are very clinching, and the circumstances taken together forms a complete chain, and there is no escape from the conclusion that it is the appellant and appellant alone who had committed the crime. And therefore the appeal should be dismissed. Coming to the circumstances as narrated by the Lanen trial court, so far as the circumstance number 1 is concerned, we find that PW4 has stated that the appellant was staying on rent in the house of one Basanti Sahu at the backside of his house. And he has further stated that he did not find Basanti Sahu in front of his house on the date of occurrence. And he further stated that he couldn't say whether the Basanti Sahu had constructed the house on the government land or on her own land, and could not say whether Basanti had how many Basanti rooms are there in the house of Basanti, and couldn't say about the occupation of the Basanti. Even though the PW4 has stated about the same in the cross-examination, and Basanti Sahu has not been examined, the evidence of PW4 that the appellant was a tenant in the house of Basanti Sahu cannot be disbelieved. Coming to the second circumstance, that the appellant followed the deceased on the date of occurrence while she was returning to her house after collecting water from a tube well. PW9 is the witness in that respect. PW9 specifically stated that he was working as a mason in the Hanuman temple, which is situated near the house of PW4. And on the date of occurrence, he was returning from the work to take his lunch. And at that time, he saw the deceased was going with a brass pot containing water from tube well, and the appellant was following her. And though the witness was cross-examined by the London State Defense Council, but nothing has been elicited in the cross-examination to disbelieve the evidence of PW9 on this aspect. Therefore, the London trial court has rightly held that the circumstance number 2 has also been established by the prosecution. Coming to the circumstance number 3, that the appellant entered inside the house after the deceased went there and the door was closed from inside, is also stated by PW9 that the when the wife of the appellant, a wife of the PW4 entered inside the house, the appellant followed her and also entered into the house, and the door was closed from inside. Number of witnesses have been examined by the prosecution, including the investigating officers. They have stated that the door of the house was closed from inside. Therefore, the London Trial Court has rightly come to the conclusion that the circumstance number 3 has been duly proved by the prosecution. Coming to circumstance number 4, that the neighbors heard the shout of one female from inside the house is stated by not only by PW9 but also by other witnesses, including PW3. PW9 has stated that when the door was closed from inside, he heard halla of the PW4 from that house, and so he called the Sahi people, and the witnesses came in front of the house of PW4. PW3 has stated that on the date of occurrence at about 2:45 p.m., while he was in his house, he heard shout on the road in front of the house of PW4, and hearing his shout, he went there, and at that time, the other persons, including PW9, were present, and they told that somebody had entered inside the house of the PW4 and there was halla inside. And he also found that the door of the PW4 was closed from inside. And when they knocked, nobody replied and opened the door. Apart from PW3, other witnesses have also stated to have heard the noise, shout of one female from inside the house of PW4. Therefore, the circumstance number 4 has been rightly held to have been established by the prosecution. Coming to circumstance number 5, that the door of the house was informant was not opened in spite of the call by the persons who had gathered near the said house, had also been deposed to by PW3 and other witnesses, and nothing has been brought out in the cross-examination in that respect. Therefore, circumstance number 5 has also been proved. So far as the circumstances number 6 is concerned, it is stated that immediately after the front side door was forced open by the neighbors in presence of the police, and the informant, they found the dead body of the deceased was lying in the prayer room of that house, and the appellant was found sitting in the corner of the said house, holding a bloodstained Qatari. In this aspect also, apart from PW4, the informant, the other independent witnesses, and the police officials, that is PW13 and PW14. PW13 and PW14 have also stated in that respect. Stop. PW4 has stated that when Police Babu came, as the entrance door of his house was not opened in spite of instruction. So the door was broke open, and they found his deceased wife was lying dead in the deity's room with bleeding injuries, and there was mark of blood from the kitchen to the deity room, and uh, there was huh, and the appellant was found sitting in the corner of the deity room holding a cautery stained with blood. The apart from the other independent witnesses, PW13, the IIC of Khordha police station, who arrived receiving the telephonic message of PW3, has also stated that at this spot he found the house of the PW4 was closed from inside, and many persons had were present. Many were present at this spot, and
Many persons from the neighboring.
from the neighboring houses were present, and PW4 was also there, and with their assistance, the door of the house of PW4 was broke open, and when he entered inside the house, he found the dead body of the deceased was lying with bleeding injuries on the face and other parts of the body inside the deity's room, and there were bloodstains indicating dragging mark of the deceased from kitchen to deity room. And the appellant uh, the deceased was lying in half naked condition, and the silver chain was lying broken there, and the appellant was found sitting in the corner near the door of the deity room holding a bloodstained kotari. The PW4 has also stated that when he arrived at the uh, spot with PW13, he found a huge gathering near the house of PW4, and the door of the house of PW4 was closed, and many persons of the locality were present there, and on the arrival of and then the IIC and other police officials entered inside the house of PW4 by breaking open the front door and found the deceased was lying dead inside the worship house with multiple bleeding injuries on her person, and the appellant was sitting on the corner of the said room holding a cutlery stained with blood. And he was caught red-handed. The London Defense Counsel has cross-examined the witnesses at length, but nothing has been found in the cross-examination to disbelieve the evidence of the witnesses. Therefore, not only from the evidence of PW4, but other independent witnesses, including the police evidence of the police officials, circumstance number 6 has been established by the prosecution. Coming to the circumstance number 7, that immediately at the spot the appellant confessed to have followed the deceased while she was returning to her house after bringing water from the tube well, and as she shouted for help while resisting the attempt made by the uh, appellant to commit rape on her, and that he committed her murder by means of pottery as people gathered outside the house hearing holla. Though this circumstance of this confession, since it was made in presence of the police officials, it cannot be it is not admissible in view of the bar under section 25 of the Evidence Act. The next circumstance, that is circumstance number 8, is the motive of the accused was to eliminate the deceased as he failed in his attempt to commit rape on her, and after she had resisted and shouted for help. Uh, the in this aspect, the evidence of the doctor who has conducted post-mortem examination over the dead body of the deceased is very relevant. The doctor has noticed the following injuries, quote kar debe injuries, and so far as injuries number
10, 11, and
10, 11, and 12 are concerned, these are the injuries which clearly indicate that these are the injuries which have been caused on account of sexual assault on the deceased by the appellant. The uh, um, uh, the finding of the bangles at the spot and by the investigating officer and its seizure also indicates that when in all probability when there was an attempt for commission of sexual assault on the deceased, there was protest from the side of the deceased for which the bangles were broken, and the deceased was also found in half naked condition at the spot which has been stated by the by the investigating officer by the investigating officer bracketary PW9 sorry PW 14 PW 14. Therefore, we are of the humble view that the circumstance number 8 has been proved by the prosecution beyond all reasonable doubt. The circumstance number 9 is the multiple external injuries, including one fatal injuries and sign of sexual assault, are found by the doctor over the dead body of the deceased, which we have already discussed in the previous paragraph, and we are of the view that the Lenin trial court has rightly came to the conclusion that the deceased, in view of the evidence of the doctor as well as the post-mortem report, that the deceased met with a homicidal death, and the injury which is the cause of death is on the neck, and moreover the weapon of offense which was seized from the possession of the appellant at the spot, that is MO1, was sent by the IO to Dr. Bracketry PW1 for examination and opinion, and the opinion has been furnished by the doctor, and he has stated that the injuries are possible, injuries particularly injuries 1 to 5, which are the incised wounds, and five are possible by swans only. Though in the chief examination he has stated, the doctor has stated that all the 13 injuries are possible by the sharp side of MO1, but in the cross examination he has stated that injuries number 7 to 13 were abrasions and bruises and were not caused by MO1. And whereas the other injuries as per the post-mortem report were possible by the sharp side of MO1. Therefore, the prosecution has proved that the deceased met with a homicidal death, and he was also subjected to sexual assault. Therefore, this circumstance number 9 has been proved by the prosecution. Circumstance number 10 is the wearing apparels of the appellant was stained with blood, and the wearing apparels has been seized by the investigating officer PW 14, and it was sent for chemical examination, and the CE report marked as Exhibit 16 clearly indicates that from the full pant and banyan of the appellant there was blood. However, no opinion could be given about its origin or its grouping. The next circumstance is the chappal (MO4) of the accused was found at the spot, and though one chappal has been though it was the one chappal has been seized from the spot by the investigating officer, but nobody has stated that it was the chappal of the appellant. Therefore, it cannot be said that this circumstance has been proved by the prosecution. The next circumstances, the last circumstance is circumstance number 12, that is the cautery which was seized from the possession of the appellant was found to be stained with human blood of group O, which tallied with the same human blood group as found in the bloodstain wearing apparels of the deceased, and with the sample blood collected from the spot. Not only the investigating officer but also the informant and other witnesses have stated about the seizure of the cautery from the possession of the appellant while he was sitting in the deity's room, and there was bloodstain on that cautery. After its seizure, the cautery was sent for chemical examination, and the C report indicates that the cautery was stained with blood, and it was of human origin and of group O group. From the spot, the bloodstain earth, the sample blood was collected with a gauze by a gauze cloth by the PW 14, the IO, and it was also sent for the C chemical examination, and the C report indicates that the gauze cloth was also of human blood and of O origin, O group. The wearing apparels of the deceased, which were seized by the investigating officer after post-mortem examination when it was produced by the constable, were also sent for chemical examination, and the C report indicates that the sari, saya, blouse, bra were containing the human blood, but so far as origin is concerned, in sari and saya, it was opined to be O grouping, whereas in blouse and bra, no opinion could be furnished. Therefore, we are of the view that this circumstance number 12 has also been rightly held to have been proved by the prosecution. The law is well settled that in a case based on circumstantial evidence, the prosecution has to prove each of the circumstances by adducing clinching evidence, and the circumstances shall not be explained under any other hypothesis, and the circumstances taken together must form a complete chain so as to come to the irresistible conclusion that it is the appellant and appellant alone who has committed the crime. In the case in hand, the circumstances which has been established by the prosecution
One circumstance of this, one more circumstance which has not been categorized on para 13 which the lower court has
apart from the circumstances which has been proved by the prosecution and has not been discussed by the London trial court is the last scene of the
category, but has discussed. Has not
been categorized in paragraph number 13, but has been discussed in the judgment.
Yes.
Is the last scene.
Yes.
And there are clinching evidence to that effect that which has been adduced by PW9 and also by the other witnesses that PW9 that the appellant entered inside the house of PW4 following the deceased, and by other witnesses regarding the presence of the appellant in the house of the deceased in the deity's room where the dead body was lying. Dead body of the deceased was lying. Therefore, the prosecution has conclusively proved that on the date of occurrence, the appellant followed the deceased while she was returning to her house after collecting water from a tube well. And then the appellant entered inside the house of the deceased and the door was closed from inside. The door was not opened even though the persons congregated outside asked for opening the door. The door of the shout of a female, which is obviously that of the deceased, was coming from the said house, which has been heard by the neighbors. The door was broke open. The door of the house of the deceased was broke open in presence of the police, and the dead body of the deceased was found lying in the prayer room of the house, and the appellant was found sitting in the corner of the said room holding one bloodstained cautery, bracketry MO1. The deceased had sustained multiple external injuries, including fatal injury on the neck, and there were signs of sexual assault on her body. There were dragging mark of the deceased and bloodstain from the kitchen to prayer room. The motive of the appellant was for commission of sexual assault, and there was an attempt for sexual assault, and there was resistance, and whereafter the occurrence has taken place. The deceased was assaulted with a cautery, and the bloodstain which was noticed on the cautery was of the same group of the that of the deceased, and it was seized from the possession of the Lekhai Chicago. The all these circumstances, the nature of injury also indicates that there was attempt of sexual assault on the victim, and that the deceased met with a homicidal death. In view of all these circumstances established by the prosecution, we are of the humble view that the chain of circumstance is complete and there is no escape from the conclusion that it is the appellant and the appellant alone who has committed the crime. The appellant has committed the house trespass, and which would be evident from the not only from the evidence of PW9 and others, but since in view of the circumstantial evidence established by the prosecution, both the charges have been duly established, we are of the view that there is no infirmity or illegality in the impugned judgment. Therefore, the conviction of the appellant and the sentence passed thereunder is upheld. We find no merit in this jail criminal appeal, which is accordingly dismissed.
I have one submission. I have one submission so far the sentence is concerned, my lord,
Yes.
subject to acceptance by your lordship. Even if it is often seen that all the session judges, while imposing the sentence of imprisonment for life, so far the 302 is concerned,
Yeah.
imposing the sentence of the rigorous RI for life, that is not permissible under law.
Why?
Yeah.
Because section 53, my lord, prescribes 6 punishments. One is death penalty, then is imprisonment for life, then imprisonment classified again to imprisonment simple SI and RI,
Yeah.
then forfeiture of property and fine.
Yeah.
So the
See,
section
imprisonment of life,
yes, ma'am.
imprisonment for life is rigorous by default. Need not be specified rigorous imprisonment for life. Imprisonment for life
I said
is rigorous. It need not be written as rigorous.
The section
No.
302 only prescribes for
Yes,
imprisonment
yes,
for life.
yes. And that is rigorous. It need not be specified. Judgments are there by the trial courts, but it is never written as rigorous imprisonment for
They
life.
have written.
It is written. We can mention it. We'll mention it.
Yes, ma'am.
But it is imprisonment for life.
Yes, only
Which is
imprisonment for life.
rigorous. Which is rigorous.
Now the rest of the thing depends upon the government. Subject to 432, you have remained in custody. But the manner in which this thing has been
Horrible.
it's horrible. Yes. So how that's all. ଲଞ୍ଚ ପରେ ଗୋଟେ ମ୍ୟାଟର କାହାକୁ ରେଡି କରନ୍ତୁ।
Item number PC. PRLA number 2 of 2014. And added in hearing list and institution that I filed IA number 2720/2023 for bail. And in fact, this matter would be the earlier bail application of the present applicant was rejected by minor honorable.
What is the number IA you tell?
2720/2020.
22.
23. The 5. Guru reject ହେଇଥିଲା ମିଲ IA number 3/2022. Order dated 2/2022.
Item number 56. That is in CRLA number 2 of 2022. Mr. Amulratna Pandal and counsel appearing for the appellant submits that an interim application has been filed for bail of the appellant by IA number 2720 of 2023. And it is further stated that earlier bail application of the appellant was rejected by Honorable Justice Sashikant Mishra in IA number 3 of 2022. List this matter before appropriate bench with IA number 2720 of 2023.
Pardon to make a mention, my lord.
Just a minute. What number it is? Yes. At T? Yes. It is mentioned since paper book has already been prepared, the matter be added to the hearing list. Learned counsel for both the parties shall file their written note of argument along with the memo of citation.
It's not matter.
It was Madam.
Yes, my lord. Matter was been entrusted to me, my lord.
Okay. So have you received the paper book?
My lord, yes, my lord.
Okay. Then you prepare the case and we'll take up this matter.
Chapter, my lord.
Okay. So that it can come in the supplementary list and can be taken up. Today, obvious supplementary list. So today is 16th. So let it come on 30th. Okay, Mr. Naik. You have received the written note of submission. You have not verified. All right, see that note. Okay. And Mr. Dhandhyan Naik, and senior advocate appearing for the appellant, and Mrs. Tripathi, and additional standing counsel for the Vigilance Department, who submitted that she is to argue this matter on behalf of the state of Odisha. Mr. Naik submitted that as per the order dated 1/8/2022, the written note of submission has already been filed with memo of citation. Okay, written note of, and he will serve a copy of the same on the learning additional standing counsel for the Vigilance Department by Monday by Monday tanko serve them. And for court you have already filed. Okay. On consensus of both the parties, leaves this matter on 30th of November 2023 in the supplementary list.
Pardon to make a mention, my lord.
Just
Several mentioned this case, revision.
please wait. I'll hear you. Please wait. Yes.
Pardon to mention, my lord. My lord, item number 32, CRLA regarding the vigilance, my lord. Here in this case, there is a 6 months delay in filing the FIR, my lord. And we are prepared. Last occasion, we have already submitted the written note of argument along with the citations, my lord. And the person is going to retire in the month of December. So
What is this matter where it is mentioned that copy of the Honorable Apex Court report?
my lord, the Honorable Apex Court report that it is requested to early hearing of the matter.
Oh, I see.
My lord.
So this matter you will argue?
Yes, my lord.
Okay, since it is a order of the Honorable Supreme Court, we have to see that.
First
Okay.
week or second week of December, my lord, fixed.
All right, then no, let it come on the next week so that we'll see. That means next Thursday would be, I don't know, the
23rd.
30th, 7th, ଆସିବ ନା? So,
My lord.
okay, 7th of December 2023 in this supplementary list. All right.
Oh, please. Oh,
Same ଲେଖିଦେବେ ଏଇ ଯୋଉ Mrs. Tripathi is to argue. Her name is to be reflected in place of Sriman Das. Her name is to be okay. Yes. Just a minute. 39 IA number 208. No. There are two interim bail applications here for bail. One is 1056 of 23. The other is 2083. Is a one appellant. Why you have filed two bail applications? No. So you are to not face one of the interim applications. So that 105C you are not facing. All right. Item number 39. That is CRLA number 716 of 2016. IA number 1056 of 2023. Mr. Mahapatra and Counsel appearing for the appellant. Seeks permission to not face this application. Withdraw this application accordingly disposed of as withdrawn. This is IA number so and so. And what is this IA number 2083 of 23? So let us see that judgment. So judgment of our 8 of 1. Wait. It's a case of conviction under 20B2C and sentence is 10 years and fine of rupees 1 lakh. So what do you say? How much period you have undergone? Custody certificate. You are a local man or outsider? Local man. Last time when you were released on bail? Date kept the Konadi. When you have been released on bail, interim bail. Okay, that is perhaps 24/1/2023. 24/1/2023 रे आईए नंबर 84 of 2023 रे अपन बेल जाइथिले तापरे आउ interim bail so and so the अपन surrender कला. Let a report be called for. As a report call for peruse the report furnished so and so it appears that has not surrendered before the warrant thereafter surrender before the he may be given. So the report indicates that you did not surrender at right time. No, it's all right. But when you surrendered? Anil Bera surrendered before this court so and so. You are supposed to surrender on 1/5/2023. But you did not surrender on that day. 8 days thereafter you surrendered. Now, you have filed an application. Your client has filed an application for early hearing.
But now the mother is ill.
Already 8 years, 7 months.
No, it's all right, but let the matter be disposed of. You get ready for hearing. Why this interim bail?
Because
No, you are not filing any interim application for bail. You are filing an application on the ground that huh? What period you are remained in custody?
8 years.
Yes, Mr. So that decision Muhammad Muslim case would be also applicable here because he has remained in custody for 8 years and kete kohuchen? Huh? 7 months out of 10 years, and he had been released on interim bail thrice, na? All right, lekhun. IA number 2083 of 2023. This is an application for bail. Considering the submission made by the Learned Counsel for the petitioner that out of 10 years of substantive sentence, the petitioner has already undergone 8 years and 7 months of sentence, and earlier he was granted interim bail by this court thrice, and even though the paper book has already been prepared, there is no chance of early hearing. After hearing the Learned Counsel for the state and taking into account the ratio laid down by the Honorable Supreme Court in case of Muhammad Muslim versus Swanso, I'm inclined to release the petitioner on bail allowed.
Pardon to make a mention, my lords. BLAPL number 11234 of 2023, my lords. The similar co-accused has been released in bail by your lordship. The this matter will become as fresh admission, my lords.
Yes, give it. Not a problem.
And maybe pardon your lordships. I'm on BC today, your lordships.
Give the memo, I mentioned. Okay.
I maybe pardon your lordships. I'm on BC. Item number 36. It's a vigilance appeal. The appellant is going to retire next year, your lordships. May I pray it may be taken up any day? I'd informed Ms. Tripathi, who was the vigilance counsel, has been assigned to her.
Not here. She was there earlier.
Delay, but yes, your lordships. I had informed her any day, your lordship may fix. ମୁଁ ଇନଫର୍ମ କରିଥିଲି ସେ ଭିସିରେ ବି ଶୁଣିଥିଲେ ଆଜ୍ଞା
ସେ ନାହାନ୍ତି ପରା ବି ଥିଲେ କୁଆଡେ ପଳେଇଲେଣି ମୁଁ କଣ କରିବି ତ
your lordship not today any other day
ହିୟରିଂ ତାଙ୍କ ପ୍ରେଜେନ୍ସ ରେ ଫିକ୍ସ ହେଲା ଗୋଟେ 30 ତାରିଖ ଦିନ ଆଉ ଗୋଟେ 7 ତାରିଖ ଦିନ ତେଣୁ ତାଙ୍କୁ
ଆପଣ I'll do that, your lordships. May put it to any other, I'll immediately inform.
All right, this is there in the list. This will not go out of the list, so this will remain.
Lordship.
But tell him so that let her be remain present. In our presence,
Lordships.
the date will fix. Okay.
I'll do that, your lordships. I'll do that.
Mr. Mr. Patro, what do you say?
I beg to pardon, Your Honor. Sometimes mention this criminal revision petition passed executed by the but did not be reached today till today for hearing the IA.
What is the number?
5161 2023
कितने नंबर क्वेश्चन
पास एक्सेप्ट बाय
2023 our assignment criminal revision. All right, it will be listed next week. Okay, it will be listed next week. All right.
Weekly list item number 1.
Yeah. Mic open नहीं की mic on नहीं की हाँ
Bolangir convicted in the appellant in section 498A 306 section 4 of PC Act and sentenced him to undergo RI for 5 years.
You are charged under what are the offenses?
498A 304B.
Just come to that charge page. Okay, 498A 304B and 4 of DP Act, right? But please come to the impugned judgment, page 9. Why it is been written that you are charged under 302/34? प्रथम जजमेंट प्रथम पैराग्राफ रे so whether you are also charged under 302/34?
No, my lord.
But in the even if in some of the pages also it is mentioned, you please come to page number 23, running page, and internal page is 15. Page 23, internal page is 23. Both the accused persons have also been tried for so and so.
It's page 38, your lordship. That charge is also there.
38,
my lords.
That concluding part. Oh, that is that 302.
Yes, your lordship.
Yes, that is there. Yes.
Also, may I read the FIR first?
Wait. Let me know that what has happened. So you come to the concluding part of the impugned judgment, that is at page 27, paragraph number 16.
As the regard the accused Lakshman Sunna, the prosecution also failed to prove its case against under section 302/304B of IPC, but is found guilty under section 498 and 306 of IPC. Read with section 4 of Dowry Act, Prohibition Act, and accompanying conduct thereunder.
So ता पूर्व paragraph टा पढ़ंतु 15 number paragraph.
In the conclusion, in view of the above discussion, the entire evidence and record, I find that the prosecution has failed to prove its case against the accused Hiralal Sunna under any of the offense charged against him, and he is not guilty of any of those offenses and acquitted thereof.
So there are 2 accused persons in before the trial court.
Right.
So out of them, one has been acquitted of all the charges, right?
Right.
The other was also acquitted of the charge under 302 and 304B, but he was found guilty under 498 and 306
of IPC.
IPC, read with section 4 of Dowry. There was no charge under section 306 of the Indian Penal.
No, your lordship.
You want to place the first information report. That is at page?
As page 33, your lordship.
पढ़ंतु
निवेदन कारण ए कि जे मु सोएंसो
ये से पीडब्ल्यू केते
पीडब्ल्यू 6 your lordship.
देबारचन छुरा so is PW 6
विवाह सोएंसो लक्ष्मण सुना को विवाह देइथिली
कोन हला
निवेदन ए कि जे मु देबारचन छुरा सोएंसो मोर झियो चंद्रमा
is the deceased in this case.
Deceased. Lakshman Sunna को so and so.
Lakshman Sunna means appellant.
Appellant. 1-9-3 लिभि जाइछि 90 मसिया रे विवाह देइथिली विवाह आगरु
9-3 ना 1-3-90 1-3-90 रे विवाह देइथिली हां 90 मसिया रे
बरंग तरफरु एक स्कूटर गाड़ी जौतुक स्वरूप दाबी करथिले एवं विवाह दिन ए विषय रे बहुत तर्क वितर्क होइतिला मु कहिथिली जे आर्थिक दशा भलो हेले ताहा देवी बोली बुझाइथिली चंद्रमा गर्भरु गोटे झियो गोटे पुओ जन्म लाभ करथिले पुओ जन्म हेबार 10 मास परे निमोनिया रे पीड़ित होई मृत्युवरण करथिला पुओ हेबा परे झियो को ट्यूबोट कमी परिवार नियोजन अस्त्रोपचार करि दिया जाइतिला पुओर मृत्यु परे लक्ष्मण सुना द्वितीय विवाह କରିବା ପାଇଁ ଇଚ୍ଛା କରିବାରୁ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ମଧ୍ୟରେ ଝଗଡ଼ା ହୋଇଥିଲା ଏବଂ ମଝିରେ ମଝିରେ ମୋ ଝିଅକୁ ମାଡ଼ ଦେଉଥିଲା। ମୋ ଝିଅକୁ ଲକ୍ଷ୍ମଣ ସୁନାର ବାପା କନ୍ଦର୍ପ ସୁନା, ବଡ଼ ଭାଇ ହଳଧର ସୁନା, ତାର ବଡ଼ ଭାଉଜ ବୈଦେହୀ, ତାର ମଝିଆ ଭଉଣୀ,
ଏଇମାନେ ଗାଳି ସେମାନେ ତ କେହି accuse
ସମସ୍ତେ
ନାହାନ୍ତି।
ନାନା ପ୍ରକାର ଗାଳି ଭର୍ତ୍ସନା ଓ ନିର୍ଯାତନା ଦେଉଥିଲେ। ମୋ ଝିଅ ଚୁପଚାପ ସବୁ ସହ୍ୟ କରି ଯାଉଥିଲା। ଯେତେବେଳେ ମୋ ଝିଅ ମୋ ଘରକୁ ଆସୁଥିଲା, ସେ ଏଇ ସବୁ ଅତ୍ୟାଚାର ବିଷୟରେ ତା ମା ସାମ୍ନାରେ କାନ୍ଦି କାନ୍ଦି କହୁଥିଲା। ସ୍ୱାମୀ ସ୍ତ୍ରୀ ମଧ୍ୟରେ ଥରେ ଝଗଡ଼ା ହେବାରୁ ଲକ୍ଷ୍ମଣ ବହୁତ ମାଡ଼ ମାରି ଘରୁ ତଡ଼ି ଦେଇଥିଲା। ମୋ ଝିଅ ଏକୁଟିଆ ମୋ ଘରକୁ ଚାଲି ଆସିଥିଲା। ତା ସ୍ୱାମୀ ତଣ୍ଟି ଚିପୁଥିଲା ବୋଲି ଆମ ସମ୍ମୁଖରେ ପ୍ରକାଶ କରିଥିଲା। ମଝିରେ ମଝିରେ ଆମ ଘରକୁ ଆସିଲା ବେଳେ କାହା ସାଙ୍ଗରେ ଭଲ ଭାବରେ କଥାବାର୍ତ୍ତା କରୁନଥିଲା କିମ୍ବା ଖିଆପିଆ ମଧ୍ୟ କରୁନଥିଲା ଏବଂ ଝଗଡ଼ା କରି ଚାଲି ଯାଉଥିଲା।
ମାନେ ଏଇଟା ହଉଛି ଆପେଲାଣ୍ଟ ବିଷୟରେ ସେ କହୁଛନ୍ତି।
ଜାନୁଆରୀ ମାସରେ ଯେତେବେଳେ ଚନ୍ଦ୍ରମା ଆସିଥିଲା, ସେ ହଠାତ୍ ଆମ ଘରକୁ ଆସି ମୋ ଝିଅକୁ ଚନ୍ଦ୍ରମାକୁ ଯିବାକୁ କହିଲା। ଆଉ ଯଦି ନ ଯିବୁ ତତେ ଘାୟଲ କରିଦେବି ବୋଲି ଧମକ ଦେଇ ଚାଲିଗଲା। ମୁଁ ଭୟରେ ଝିଅକୁ ତତ୍କ୍ଷଣାତ୍ ତାଙ୍କ ଘରକୁ ପଠେଇ ଦେଇଥିଲି। 17/3/97 ମୋ ପୁଅ ଚନ୍ଦନ ଛୁରା ଓ ତା ସାଥୀ ପିଲା ଭରତ ଲାଲ ନାଗ ଅପରାହ୍ନ 4ଟା ସମୟରେ ଲକ୍ଷ୍ମଣ ସୁନା ଘରକୁ ଯାଇ ଚନ୍ଦ୍ରମାକୁ ଲକ୍ଷ୍ମଣ ସହିତ କଥାବାର୍ତ୍ତା ହୋଇ 1 ଘଣ୍ଟା ପରେ ଆସିଥିଲେ। ଅନ୍ୟ ଦିନ 14/3/97 ଦିବା 1 ଘଣ୍ଟିକା ସମୟରେ ଆମେ ଖବର ପାଇଲୁ ଯେ ଚନ୍ଦ୍ରମା ନିଆଁରେ ପୋଡ଼ି ମରିଯାଇଛି। ଘଟଣାସ୍ଥଳରେ ପହଞ୍ଚିଲେ ଦେଖିଲେ ଶବର ଉର୍ଦ୍ଧ୍ୱ ଚକ୍ଷୁ ଜୀବ ବାହାରିଥିଲା। ପାଦ ଓ ମୁଣ୍ଡର ବାଳ ପୋଡ଼ି ନଥିବା ଦେଖି ଆମର ହତ୍ୟା ସନ୍ଦେହ ଜାତ ହେଲା। ତଦନୁସାରେ ଆପଣଙ୍କୁ ଜଣାଉଛି। ଏ ବିଷୟରେ ତଦନ୍ତ କରି କାର୍ଯ୍ୟାନୁଷ୍ଠାନ କରିବେ।
So it's a case of burn injuries.
Burn injury. And the date of incident is 14/3/97. And the date of affair is 23/4/97. After 1 month and near about 1 month 10 days thereafter. Which I'm reading the judgment, Your Lordship.
Just a minute. So, since the date of marriage was 1/3/1990, and the occurrence took place on 14/3/97, 7 years had passed. That is why you are acquitted of the charge under 304B, right? And doctor is PW?
Doctor is, Your Lordship, PW.
8, Your Lordship.
8.
PW 8 doctor. He has stated about cause of death was on account of burn injury.
Burn injury, and she stated that she cannot say whether it is accidental, suicidal, or homicide.
So that may be the reason for which you are acquitted under 302.
Again.
PW 8.
And there is no extra
injury ଆଉ କଣ ଯଦି ପୋଡା body part ପଡିବ injury କୋଉଠି ଦେଖାଯିବ ତାକୁ unless ସେ type ର PW 8. Paragraph number 3, page 69. Death was due to extensive burn by antemortem in nature. No evidence of violence could be found on the body of the deceased. The injuries found on the body of the deceased was very extensive, and therefore it is sufficient to cause death in ordinary course of nature. On 5/9/97, the IO made a query whether the burn of the deceased was homicidal, accidental, or suicidal, and the extent and degree of burn and the possibility of cause of death, and whether the skin of both The feet and right hand, as per PM report, was not burned, and whether it was due to any possible obstruction. My reply is like this. Okay. As the body was extensively burnt with charring, it was not possible to say definitely whether it was accidental, homicidal, or suicidal in nature. But we have to find that the burn was antemortem in nature. No injury on the remaining part of the skin or deeper substitutions or any fracture or dislocation could be found. Burn was extensive, deep in some areas, particularly upper part of the body, face, red swans. Death was immediate and due to extensive burn. No injury on the unburned part of both the legs of the swan, so it was not possible to opine about obstruction. However, nothing suggestive of foul play could be found on the parts of the body. So this is the report of the doctor. Now, when you are found guilty under three offenses, that is 498A, 306, and Section 4 of Dowry Prohibition Act, who are those witnesses who have stated about the any demand or any torture?
PW1,
just a minute. PW1 kiye?
the mother.
Mother. Tapre?
PW2,
ठीक है.
neighbor.
ନେବର ମାନେ କାହା ନେବର? ମାନେ ତାଙ୍କ ସେପଟର ନେବର ନା ମାନେ ଝିଅ ଘର ତରଫ ନା ଏଠି? ଝିଅ ଘର ତରଫ.
And may star witness होची PW6.
Father. मते PW6 किए?
Father.
Father. अब भाई भौणी एमन के एग्जामिन ही ना थी?
Yes, brother as well.
Brother भी अच्छी.
के PW?
It is 7, your lordship.
7. Okay. Another thing is that this burn injury you are sustained on 14/3/97. So she was dead on that day or
that day?
That day. So her dead body was lying in that.
ଗୁହାଳ ଘରେ ପଡିଥିଲା କହୁଛନ୍ତି.
So if you say that PW6 is the star witness, let us begin the that witness reading that evidence.
One टा टिके आगे पढ़ दूजे. One टा ता mother अच्छी. I know the accused persons.
Wait.
47.
Yes.
I know the accused persons. Accused Lakshman is my son-in-law, where accused Hiralal is his brother. Deceased Chandrama was my second daughter. She has given in marriage to the accused Lakshman 7 years back, and we had given dowry during marriage to my son-in-law accused Lakshmana. During the marriage also demanded a scooter, but we could not fulfill the demand due to poverty, and we assured to give the same latter on availability of fund. Accordingly, the accused Lakshman agreed such proposal and marriage was solemnized. After marriage, my daughter was sent to the in-laws' house, but she had no peaceful living there. In all days, there was quarrel and misunderstanding of the deceased with the in-laws of my daughter. Sometimes she was assaulted by them. Accused Lakshman also assaulted the deceased.
Assaulting
the deceased. Accused Hiralal was also insisting my daughter to bring the scooter. When the deceased daughter used to come to our house, she was telling about the assault and ill treatment to her. In the month of March, the occurrence year, while my daughter was in our house, accused Lakshman came there and threatened my daughter to go with him, otherwise she would be assaulted. Out of fear, we sent our daughter with him with her in-laws house. After the departure on 13/3/97, we sent son Chandana Chura and his friend to the in-laws house and the deceased with some articles. After talking with the deceased, he returned to us. On the next day, on 14/3/97, a person accused Lakshman of village come and informed that your daughter has been died uh, burning in the cow shed. Hearing, I cried, and others came. Then my son and his friends went to the village uh, Dongri Dungri Pada, the village of the accused, seeing the deceased lying in the dead, having burn injury on her face and burning her there of her clothing, bangles intact, and her hands came and informed the same to me. My husband also sent and came and went again to the village Dangripalli on that day.
Yes.
My lord, I am Harijan
So
by caste.
one thing he has stated about that demand of scooter, and then he has stated daughter was complaining because of the assault by the in-laws, including you,
including the husband,
and that was disclosed to by none else than the deceased. And then few days prior to the occurrence, she had gone to the house of the appellant, that means her in-laws house, and 13th she was visited, everything was all right. Then on 14th she died.
ଏଇ କଥା ଗୁଡ଼ା ସିଏ ଡେଭଲପ କରୁଛି ବର୍ତ୍ତମାନ, କାରଣ PW1 ଆଇଓ ଆଗରେ ଏଗୁଡ଼ା କହିନଥିଲା। ଆଇଓର ଷ୍ଟେଟମେଣ୍ଟଟା ପଢିବି।
Just
page 75, para 8. I have examined PW1. She has not stated before me that while her daughter was in their house, accused Lakshmana Sunna came and threatened my daughter to go with him, otherwise she will be assaulted. Out of fear, they sent their daughter with him with their in-laws house, and that she had not stated before me that hearing the death of the deceased, she cried, and others came, and thereafter her son with her friends went to the village of the accused and found the deceased lying dead in the in-laws house with burn injuries on her face and burning hair, and there her clothes and bangles were intact in her hands.
come to the evidence of PW6, whose version has been accepted.
And it's just a love marriage, your lordship.
PW6 page number?
PW6
58.
58. I know the accused person. Accused Lakshmana Sunda is my son-in-law, and other accused is his brother. Deceased Chandrama was my first daughter. The deceased has married to accused Lakshmana on 1/3/90. The accused Lakshmana demanded his scooter as dowry prior to marriage, but due to the poverty, I could not fulfill the demand. At the time of marriage, accused Lakshmana protested for not giving scooter and expressed not to marry unless it was given. When I gave wristwatch and ring to him during the marriage, other gentlemen present, including myself, persuaded him to marry, and later on availability of fund, scooter would be given. Accordingly, the marriage was solemnized. The marriage was solemnized in the village of the accused. After the marriage, Chandrama has begotten a female child. Whenever my daughter was coming to my house, on all occasions, actually Lakshmana reminded me my daughter for giving scooter as committed earlier. Sometimes after Chandrama was blessed with a male child. Thereafter, Chandrama suffered from tumor, and while he was operated, tubotomy operation was done to her. The male child was died 10 months after due to pneumonia. After the tubotomy operation and the death of male child, on consultation with the physician, they ascertained that there is no guarantee of further conception. And the accused Lakshman, apprehending no male issue through the deceased, tried to have second marriage because of the reason. The deceased and the actual Lakshman were quarreling with each other, and Lakshman assaulted her on some occasions, for which the deceased came to my house. The deceased was also complaining of ill treatment by accused Lakshmana, and once he was threatening her to do away her life. In the following December, my daughter was sent to her in-laws' house. Then, in the year 97, in the month of January, once again my daughter with the granddaughter came to our house. Sometimes after the accused Lakshmana came to our house and asked my daughter to go, who did not agree, and thereafter accused Lakshmana threatened to assault if he would not go with him. For this, he was sent back to her daughter to her in-laws' house. The following March, as per my suggestion, my son Chandan went to the in-laws' house to my daughter with clothing and
ସେ ଚନ୍ଦନ ଏକ୍ସାମିନ ହେଇଛି ପାରାଗ୍ରାଫ 4 ରେ ଯୋଉ ଚନ୍ଦନ ଯୋଉ ଯାଇଥିଲା
PW7.
PW7, okay. Pardon.
In the following March, in my suggestion, my son Chandan went to the house of the daughter with clothings and bhara. In 13/3/97, and returned giving those articles about evening after taking food. On the next day, on 14/3/97, I went to school for my duty at about 1:30 p.m. I was sent by two persons who informed me that my daughter had died due to burning in the village Darlipalli. Hearing this, I came to the house and found my wife and other members was crying, and I verified the news from them. On my query as to anybody has been sent, I was informed that Chandan and his friend had gone to Darlipalli. When I went in a scooter with Jyoti to the village, after reaching the village, I'm asking where the deceased was lying. I was informed that she was lying in the cow shed, and my going inside the cow shed, I found the daughter lying dead. Others were also coming to see her. I found there was burn injuries on some of the places of the body, but her hair and head and the feet were not burned. Seeing the condition, I suspected that she had been killed by someone. From that place, I myself, Jyoti, went to Belpada PS in his scooter, and thereafter I lodged a report. This was a report which was submitted in the Belpada PS Exhibit 3, and the report Exhibit 3.1 as my signature thereon. On 15/3/97, the police did inquest over the dead body in my presence of the magistrate in the village.
Go to the detail, but come to that evidence of PW7, because he is the person who had visited the deceased just one day prior to her death.
Well,
so let us see the.
I know the accused Lakshmana, who is the husband of the deceased Chandrama, and also the accused. On the date and time of marriage, while my father was giving a wristwatch and a ring to the accused Lakshmana, he was annoyed for not being given a scooter and refused to marry unless he was given a scooter. The gentleman present there tried to convince accused Lakshmana that he agreed, and marriage function was solemnized. After the marriage, they were leading a peaceful life, and intermittently there was quarreling at times. Accused Lakshmana asked my sister to bring scooter, and accordingly my sister told my mother regarding the demand of scooter, and accused Lakshmana and this is I heard from my mother.
Leave it. Next one.
As my sister went to her in-laws' house without taking anything, I, along with my friends Bharata, with articles, went to in-laws' house on the date prior to death of the deceased and gave all those things. We stayed there for an hour and came back. On the date the accused Lakshmana was present in his house, I saw my sister who was in shifting grains from the chaff, and I talked to her, and staying for a moment, I came back. On the next date, I informed in our village that my sister died burning. Hearing, I, along with Bharat and my friend, went to the village of Aripala, accused Lakshmana near heap of the straw, and my asking what happened to her, he informed that the deceased lying inside the cow shed. Then I entered inside the cow shed and found the deceased lying dead. I suspected that he has been killed. I cannot say to whom I suspected for her death.
Okay, as I find, subject to what you that whatever demand was there, that was for a scooter. Other was the things were fulfilled, but that scooter demand could not be fulfilled on account of financial difficulty, right? Then, as usually, there was some torture on her. Then some mishap happened. Her son
Son died.
passed away, and perhaps the gynecologist to find that she cannot give any birth to any child, for which there was a proposal. Most likely, he was to marry for the second time. But if we come closer to the date of occurrence, as it appears that the deceased was uh, when he came to stay in her father's place in January, the accused came there.
Yes.
And said that you should go immediately to your in-laws' house. But he did not go there. He went after some time. Immediately बोधे से जाएंगे. तापरे ଯେତେବେଳେ ଯାଇଛି ଖାଲି ହାତରେ ଯାଇଛି ମାନେ
ସେଗୁଡା ସବୁ ଡେଭଲପ କରାଯାଇଛି କାରଣ ଆଇଓ ପାଖରେ ଗୁଡା ସେମାନେ କହି ନଥିଲେ.
We will see that. So then this man had gone on 13th to the house of the appellant, and the gifts were there, and he presented it, gave it, then came back. And on the next day, this occurrence has taken place. So, apart from
ପ୍ରଥମେ ୟୁଡି କେସ୍ ରେଜିଷ୍ଟର୍ଡ ହେଲା. ୟୁଡି କେସ୍ ର 1 ମାସ 10 ଦିନ ପରେ ଏଫଆଇଆର ହେଇଛି.
So, what is the let us say that it is the prosecution has proved that it's a case where the deceased has, because 306 conviction means you have to prove first that she has committed suicide. So she has sustained burn injuries. So the doctor says that it was not possible to say definitely as to whether it was an accidental death, whether it was an homicidal death, or it was a suicidal. So how the London trial court came to the conclusion that it was a case of suicidal in nature, so that the person who abated the crime can only be convicted under 306. So जदि आपनकर पोस्टमार्टम रिपोर्ट रो डाक्टर इज नॉट सियोर, से कहूची एटा मु कहि परिबिन एटा एक्सीडेंटल डेथ हबो. एक्सीडेंटल डेथ हिल तो इरेस्पोंसिबल आसीबन ना.
Yes.
होमिसाइडल डेथ रही पर होमिसाइडल डेथ माने से तो एक्यूटल ही सालानी. बाकी 306 पाई जोटा दरकार जणे केमती बाकी जदि डॉक्टर एविडेंस नाही कोन सर्कमस्टेंशियल एविडेंस अछि जो थ्रू कि जना पड़ुछि जे डिसीज्ड कमिटेड सुइसाइड because the dead body was lying in the cow shed, right?
Yes.
With burn injuries. ତେଣୁ ସେଇଟା ଯଦି prosecution ନ ଆଣି ପାରିବ, how that has been dealt with by the London trial court, that it is a case of suicide.
Para 14,
14,
my lord, page 25, internal page 17. Yes, basically, of course, there is no medical evidence, but given the aspects of torture and demand of dowry, and clubbing all these aspects, he has held that even though it cannot be conclusively said that it's homicidal, but it seems to be suicidal. That is his exact wording, Your Lordship. So even though
ଆପଣଙ୍କର ସେ ଯୋଉ accidental जदि homicidal नुहे ताले accidental को मध्य rule out करिवार थिला. आपण पॉजिटिव फाइंडिंग देबे ना. आपण गोटे चार्ज ही नाही 3069. But
Yes.
law is there, even if that charge is not there, one who has been found guilty, charged under section 304B, if material doesn't come that there was any demand of dowry, but it is a case of suicidal death, and there is also material that for some other reason the abatement has been made for which the deceased committed suicide, then 306 conviction can be made merely because said that 306 conviction cannot be sustained. That part is there. You also examine this.
My lord, there
because-
is a judgment of your lordship that is
Huh.
say e part ଅଛି 2023 91 OCR 718
Hmm.
ସେଥିରେ ସେ ବି ଆପଣ ଲେଖିଛନ୍ତି ଯେ ସେଇଟା ସେଇ ଏକ୍ଜାକ୍ଟଲି ସେଇ ଡିସିସନ ରେ
ହଁ
ଅଛି
ସେ ନାଇଁ ସେଟା there is other decision also, ମୋ decision ଛଡା ଅନ୍ୟ decision
ପ୍ରହ୍ଲାଦ ବେହେରା and others
ହଁ।
versus state of Odisha।
ତେଣୁ 306 ର ଚାର୍ଜ ନୁହେଁ, ମାନେ ନୁହେଁ ଯେ ଆପଣ କନଭିକ୍ସନ ହେଇପାରିବନି ଯଦି 302 ଏବଂ 304B ର ଚାର୍ଜ ଅଛି। 302 ର ମ୍ୟାଟେରିଆଲ କିଛି ନାହିଁ ହୋମିସାଇଡାଲ ଡେଥ ର, ସେ ଆକ୍ୟୁଟାଲ ହେଲା। 304B ର ସେ ଯୋଉ 7 years ଯୋଉଟା ମ୍ୟାଣ୍ଡେଟୋରୀ ରିକ୍ୱାରମେଣ୍ଟ ଇଜ ଦେୟାର, ସେଇଟା ପାସ୍ କରି ଯାଇଛି, କାରଣ ଏଟା 7 ବର୍ଷ 3 ମାସ ପରେ ଘଟଣାଟା ହେଇଛି। ସୋ ଦ୍ୟାଟ ଇଜ ଜଷ୍ଟିଫାଏଡ। But again, you are to at least, if medical evidence is not there, by oral evidence or circumstantial evidence, you are to bring on record that it is a case of suicidal death. Otherwise, 306, it says about the abatement of suicide. Unless you prove it is a suicide, where is the question of abatement? So who has proved that or where is the finding that it is a case of suicidal death?
That is at he has given at para 14, your lordship, of the judgment.
Paragraph 14.
Yes, your lordship.
Page kete?
Page 25, internal page
Just
70.
a minute.
The death of the deceased has occurred otherwise than under normal circumstances. She was a young lady having her daughter alive. From the evidence of the witnesses, it also appears that the deceased had no peaceful living in her in-laws' house. Accused Lakshman Suna not only physically and mentally tortured the deceased, as appears in the evidence of the witnesses, he also did not allow the deceased to stay in her father's house for some time to avoid his ill treatment and torture. The threatening of accused Lakshman to have a second marriage because of the incapability of the deceased to give birth to a male child must have given sufficient mental agony to her. All these events added salt to the injury, that is, the helplessness of the parents to fulfill the demand of a scooter. Thus, the death of the deceased is, if not homicidal, definitely seems to be suicidal in the facts and circumstances as indicated above. Hence, the irresistible conclusion is to be drawn that the deceased committed suicide in consequence of cruelty or torture meted out to her by accused Lakshman, and this is sufficient to constitute the offense of abetting suicide, punishable under section 306 of the IPC. It is no doubt true that where an accused has been charged for it, then he has held the same thing, Your Lordship, because he was charged for a higher offense.
No, there is no problem there.
Yes,
we are
yes.
not on that.
So
We
this
are
is the finding on that the trial court has given.
Acha, let us see that how the deceased was lying there and who has stated about this and what the IO has seen this in this spot. When because there is it's a case of UD case was initially registered.
Yes.
So who has seen the dead body? It was that was death at the spot itself, not that it was removed to the hospital and treatment was given and subsequently died. Yes, Mr. Tripathi, Mr. Mishra.
Lordship may take the deposition of the IO.
Okay.
Page 72. The inquest over the body was held at the spot, I believe, Your Lordship, because he had deputed a constable to guard the dead body of the deceased. Then he has stated, I sent requisition to the STJM Patnagar to depute a magistrate.
Just a minute.
My lords.
ठीक है ता पूर्व आस एग्जिबिट 3 टा टिके देख हां एग्जिबिट 3 टा होची एटा देवार्धन छुरा माने से जो इनफॉर्मेंट हां से एटा दिया हिची सेही दिन से 14/3/2097 रे एटा मार्क हिची एग्जिबिट 3 हिसाब रे विषय मोर झियो चंद्रमा सुनार जली मृत्युवरण संबंधे निवेदन अभिप्राय कि जे मु देवार्चन छुरा निज झियो चंद्रमा को डुंगुरपाली निवासी कंदर्प सुनांकर सान पुओ लक्ष्मण सुना सहित 1990 मसीह विवाह देइथिली झीर प्रथम जात संतान एक झील द्वितीय जात संतान एक पुओ हेबा समय चंद्रमार पेटरे गोला थिबारु ट्यूमर गुडा ताकू नहीं विषम कटक स्थित डाक्तरखाना ऑपरेशन कर दिया जाइथिबा बेले लक्ष्मण सुना को इच्छानुक्रमे चंद्रमा को फैमिली प्लानिंग ऑपरेशन मध्य करा जाइथिला ठीक 10 मास परे तार द्वितीय संतानर मृत्यु हो जाइथिला सेही दिन ठार लक्ष्मण सुना द्वितीय स्त्री विवाह करिवो बोली झियो कहि आसुथिला एवं धमक देउथिला आज 14/3/97 दिन हठात दिन गोटाए बेले तार गाँ सुआनसोरु जड़े लोक आसी खबर देला चंद्रमा तांको स्वामी घरे गुहाल रे जड़ी मृत्युवरण करिछि यह संपूर्ण संदेहजनक मन हुए अच्छा this was treated as UD case was instituted and during course of that UD case inquiry the it seems that the postmortem was conducted and postmortem heichi tadar lekha heichi place where the dead body was found mutofi कि ग्रामर लक्ष्मण सुनाଙ୍କ घरर उत्तर दिगरे थिबा गुहाଳରେ मड़ी पड़िथिबा पायागला एवं तार ओके
One kerosene bottle was also found at the spot with some matchboxes.
who has stated that
The IOA.
देखिए
Paragraph 2, page 73.
I seized one kerosene bottle, 3 pieces of broken bangle and a matchbox one. So I dispatched the dead body for swan. Okay, have you gone through that Modi's jurisprudence and Taylor's jurisprudence that in a case of burn injury, how देखिए come to the chapter of burn injury.
Lordship.
Paragraph number 20, chapter 22, 541. No, Mr. Tripathi, you please come. Mr. Misra,
My lords.
just see that paragraph number 2 of page 73. जो आईओर एविडेंस टा प्लेस कले आपण
Lordship.
at 1 p.m. on 15/3/97 I seized one kerosene bottle,
My lords.
3 pieces of broken bangle and a matchbox in presence of witnesses. हैला
My lords.
तो kerosene bottle जदि सीज हला ताले kerosene आ पकेला कोठु एटा एम्प्टी बॉटल थांदा नले एटलीस्ट अल्प थांदा तो kerosene bottle टा जदि पूरा थिला से तो कहूनी एटी पार्शियली थिला बेली तो कौज गोटे किरोसिन बटल टा जबत हला सेठी आउ कोनोसी बटल थिला बेली कहूनी तो को बटल किरोसिन निजे निजे तो पुनी ढाली थिबो जदी सुइसाइड करथिबो आपनकर because you come to the PM doctor's evidence
से कहूचे no smell of chemical like kerosene.
kerosene
But black soot particles were found inside, which is, as per Modi's jurisprudential lordship, that is related to kerosene. If black soot particles are found on a charred body, so that is one piece is there.
burn of so parts of the body, so no pieces of partial. Exhibit 8 of her. तळगु नियो रो बैक कर हाँ एटा हाँ एटा exhibit 8 cow shed of Lakshman Suna situated at so and so article seized गोटे काच्य बोतल रंग धूसर जयरू अधारू अधिक किरोसिन तेल भर्ती होई थाई हाँ ये आउ गोटे अच्छा काच्य बोतल खाली थाई तो सेई गुटा को एटा सेटा कहूनी खाली कहला one kerosene bottle in fact there
Two
were
bottles.
2 bottles
Got it.
one is empty ସେଇଥିପାଇଁ ଏଗୁଡା ସବୁ ପ୍ରସିକ୍ୟୁଟର ଏଗୁଡା ମାନେ ବୁଝିବାର ନାହିଁ ଯେ କେମିତି ତାହେଲେ ଆରେ କେମିତି ହବ ଗୋଟେ ବୋତଲ ଯଦି ଇଏ ଥିଲା ତାହେଲେ ଆଉ ଗୋଟେ ବୋତଲ ନଥିଲେ ତା ଦେହରୁ ଖାଲି ନଥିଲେ କିରୋସିନ ଜଣେ ପକେଇବ କୋଉଠୁ ତା ନିଜେ ଦେହରେ ଢାଳିଲେ ପୁଣି ନିଆଁ ଲଗେଇବ ତ
Lordship.
so that is the importance lies there ଗୋଟେ ଧଳା ରଙ୍ଗର କାଚ ବୋତଲ ଖାଲି ଥାଏ all right let us accept for the that for the time being that it's a case of suicide
Lordship.
but again for attracting 306 जो abatement टा ହେଇଥିବ तार किछि conduct there must be some proximate link between the conduct of the accused with the commission of suicide ताहले 306 रे abatement हो गोटे स्टेल इंसिडेंट ହେଇଥିବ बहुत पुराना ହେଇଥିବ ता पई आपण कहितबे से हमको ये ला ता तेणु व्हाट इज दी मटेरियल on record that it is not soon before, that word has not been used, but again the decisions are there that there must be proximate link between the death and some overtact which has been committed by the accused. ଏଠି ଯଦି ଆମର ଏଭିଡେନ୍ସ କୁ ଆମେ ଡିସ୍କସନ କରିବା ତ 13 ତାରିଖ ଦିନ ତାର ଯୋଉ ଲୋକଟି ଯାଇଥିଲା PW7 ସିଏ କିଛି କହୁନି ଯେ ମତେ ମାନେ ଡିସିଜ କୌଣସି ମୋ ଆଗରେ କିଛି କମ୍ପ୍ଲେନ କରିଥିଲା ବା ମୁଁ ତାକୁ ଦେଖିଲି ଟର୍ଚର ହବାର ମାନେ ଘଟଣା ପୂର୍ବ ଦିନ ହେଲା। ବାକି ଗୋଟେ ଘଟଣା ଆସୁଛି ଜାନୁଆରୀ ମାସରେ ଯୋଉ ଦିନ ଯେତେବେଳେ କି ଡିସିଜ ଆସି ରହିଥିଲା ବାପ ଘରେ, ଆକ୍ୟୁଜ ଆସି କହିଲା ତୁ ଜଲ୍ଦି ଘରକୁ ଚାଲ। ଆଚ୍ଛା, ତାପରେ ସେ ପଳେଇଛି, ବଟ୍ ତାପରେ କିଛି ଏଭିଡେନ୍ସ ନାହିଁ ଯେ ସେଇ ଯୋଉ 2-3 ମାସ ଯାଇକିନି ଶାଶୁ ଘରେ ରହିଲା ସେତେବେଳେ ତାକୁ କୋଉ ଟାଇପ ର କିଛି ଟର୍ଚର ହଉଥିଲା, କି ଯଦି କରୁଥିଲା କିଏ କରୁଥିଲା କଣ ଏଇ ଟାଇପ ର ଏଭିଡେନ୍ସ ଅଛି କି ନାଇଁ ଦେଖନ୍ତୁ। କାରଣ ଯଦି ସେ ଏଭିଡେନ୍ସ ନାହିଁ, ବାକି ଯୋଉ ଏଭିଡେନ୍ସ ରହୁଛି ଯେ ବାହାଘର ବେଳେ 7 ବର୍ଷ ତଳେ ଗୋଟେ ସ୍କୁଟର ମଗା ହେଇଥିଲା ଆଉ ସେଇ ସଂକ୍ରାନ୍ତରେ ତାକୁ ହେଇଥିଲା, ଇଏ ଗୋଟେ ପ୍ରକାର। ଦେନ୍ another type of mental cruelty you can say that ଯେହେତୁ ତାର ପୁଅଟା ମରିଗଲା ଏବଂ ଡାକ୍ତର କହିଲା ଯେ ଇଏ ଆଉ ମା ହେଇପାରିବ ନାହିଁ, ତେଣୁ ସିଏ ଚାହୁଁଥିଲା ଦ୍ୱିତୀୟ ବିବାହ କରିବାକୁ। ଦ୍ୟାଟ୍ ମେ ବି କାଇଣ୍ଡ ଅଫ mental torture or harassment କୁହାଯାଇ ପାରିବ ଯଦି ସେଇ ସେନ୍ସରେ ନିଆଯିବ। But again it must be something which has proximate link with the death। ତେଣୁ ଏଇ circumstance ରେ ଆପଣ ଯୋଉ material ଅଛି ତା ଦ୍ୱାରା କେମିତି ଆପଣ how do you establish the proximate link? Have you brought any decision under 306 about this proximate link which has been held many decisions? ଏଠି ଆସିଲେ come here. ଏଇଟା ମନୁ ଷଷ୍ଠ ହଁ ଦିଅ ମତେ ଏଇଟା ଉଠେଇ ଦିଅ।
In M1 versus State of represented by Deputy Superintendent of Police, 2011 48 OCR, it was held as follows. Abatement involves mental process of instigating a person or intentionally aiding a person of doing a thing. Without a positive act of the part of the accused to instigate or to aid commit suicide, conviction cannot be sustained. It is 2011 48 OCR, Supreme Court 961.
ମୁଁ ଯୋଉ ୱାର୍ଡଟା ୟୁଜ କରୁଛି ତାକୁ ଲେଖିଲେ ଦି ଜଣ ଯାକ proximate link
Yes, your lordship.
in 306 case. Okay,
My lordship.
I'm giving you some of the decisions on that, including our court. Just examine those decisions. Yeah, come here. without a decision, Lekhondu, it was M. Mohan versus the state. It is reported in 2011, volume 3 SCC 626. Okay. And after discussing the ingredients of section 306, then about the abatement, word abatement as appears in section 107 of the Indian Penal Code. It is many decisions have been taken into account where it is held that abatement involves a mental process of instigating a person or intentionally aiding a person in doing of a thing without a positive act on the part of the accused to instigate or aid in committing the suicide, conviction cannot be sustained. Say case in the instant case, what to talk of instances of instigation, there are no allegation against one, so there is also no proximate link between the incident of 14/1/2005 when the deceased was denied permission to use the Qualis car with the factum of suicide which had taken place on 18/1/2005. So se taku magithila kon Qualis car e delani. So मना कर देइथला तापरे 4 दिन पर से सुइसाइड कला. So सेटा कहले जे it cannot be said that so what they have stated that the person must intentionally aid the person who is committing suicide for doing that thing, so that without a positive act on the part of the accused to instigate or aid in committing suicide, conviction cannot be upheld. So this is one very language is very clear. Then
there is another decision approximately link ଉପରେ ବି ଅଛି ସେଟା ହଉଛି ସେଇ 2391 OCR page 718 M1 को डिसीजन भी ये ହେଇଛି ଆଉ
ए डिसीजन टा नोट करंतु रविंद्रनाथ देव versus state of Orissa. एटा डेट ऑफ जजमेंट होची 6/2/2017. एई देखिबो लेखुछ तो एटा ओसीआर देखो बाहर थिबो एप्रिल आडू कि मे आडू देखो 6/2/2017 हो जजमेंट हला. So here what has been held A. Mohan decision that is also quoted. Then another decision was taken into account in that decision. That is Madan Mohan Singh. Likhi diyon data. Madan Mohan Singh versus State of Gujarat. That is 2010, Volume 8, Supreme Court Cases 628. Oh, so many decisions have been quoted there. और से डिसीजन टा देखो बाहर करंतु गुड़ाई डिसीजन ता जरे ये and ultimately what has been held that there is no material on record that the petitioner instigated or aided the deceased in committing suicide. There is no nexus or proximate link between the suicide of the deceased and any of the alleged act on the part of the petitioner which appears to have been performed in due discharge of the duty. से केस रे बोधे से पुलिस ऑफिसर टा ताकू नहीं किनी ये करथिला से सुसाइड कर दला से लोकड़ा. So that is how it has been said that no 306 ସେଟା ପାଇଲେ ସେ decision ତ ଲେଖି ରଖୁଛନ୍ତି ତ. Then recent decision ଗୋଟେ ରହିଛି ମୋ decision ଟା single bench decision ଟା this decision it's a Prahlad Behera and State of Orissa. এটা 27/2023 ରେ judgment ହେଇଛି.
ସେଇଟା 2023 91 OCR 718.
ହଁ ସେଟା ରେଫରେନ୍ସ କର. ସେଟା ଅଛି ଆପଣ ଆଣିଛନ୍ତି? ହଁ ତା ଦେହରେ ବି ଡିଲ୍ ହେଇଛି ପାର୍ଟଟା. The intention of the legislature is clear that in order to convict the person under section 306 IPC, the clear mens rea to instigate a person to commit suicide must exist. It also requires active or direct act which lead to the deceased to commit suicide, seeing no other option. And this act must have been intended to push the deceased into such a position that he/she committed suicide, where the accused by his continuous course of conduct, creates circumstances under which the deceased was left with no other option than to commit suicide. The instigation or intentional aiding may be inferred. It is not enough if the acts of the accused caused persuasion in the mind of the deceased to commit suicide. In some cases, there may be several reasons for creating great disturbance to the psychology of the deceased, which resulted in the commission of suicide. One of such reasons may be due to some overt act committed by the accused at some point of time. But unless there is proximity and nexus between the conduct and the behavior of the accused with that of suicide committed by the deceased, it would not be proper to convict an accused under section 306 of the Indian Penal Code. So, for example, suppose the wife said that take me to for purchase of some ornaments, let us say. Husband says that, no, I have financial difficulty. I cannot purchase the ornaments now. I have not got the salary. Today is the 15 or 16. So he says, and there was some kind of quarrel, or then the husband left the house and the wife committed suicide. So can it be said that the husband abated the commission of suicide? Number one example. Another example. Poor marks have been obtained by a son or daughter. Father sees the progress report, abuses that to they kichi havan to जीवन ने किसी करी परिबनी. Took it as an exception, commit suicide. Can the father be said that he has abated the commission of suicide? So question is that circumstance जो गुड़ाक आसुची माने accused ର conduct ताकू देखिवा को पड़िवो लाइव लिंक सी हुए तो ताकू एक्सेप्शन नहीं जाई पारे माने एटी ए जो केसटा सेकंड एग्जांपल ले बापा काई एमती कहला मते खराब कर देछि बापा प्रोत्साहित करिया कथा ए हां हला जा हला एमती कहया जे सब बापा से या कहबे बोली किछ माने अछि यदि बापाटा गाली देई कि ने या कहिछि तो दे किछ हबनी ता माने कोन बापा तते कहला जे सुसाइड करियो अबेटमेंट को लागि सुसाइड करियो सो एवरीथिंग दैट इज टू बी नॉर्मली गोटे देखिबा को पड़ियो इलीगल कोनोसी जिंसटा गोटे इलीगल डिमांड रहुथिबो त दैट इज अ डिफरेंट थिंग एठी जो आपनकर एविडेंस आसुची जे बाहागर पर गोटे पुओ झियो हला राइट झियोटा होची बड़ एई केस रे
Yes.
पुओटा होची तापरे हला पुओटा निमोनिया रे मरि गला डाक्टर कहला जे आउ ये सेकंड आउ मा ही परिबो नाही तेनु सेई सर्कमस्टांस रे ये डिसीज को कहला जे पुओ नाही मु सेकंड विवाह करिबी मे बी दैट इज पेनफुल टू दी वाइफ जे तार दोष कोन जे पुओ जदी मरि गला निमोनिया रे तार व्हाई इट्स ऑल राइट बट अगेन दैट से जो इंसिडेंट केबे हला आई वेदर से पाई से कंटीन्यूअसली आउ किछि कहउथिला ना खाली बाहाबा पाई कहउथिला जदी कहउथिला केबे कहिथिला ता पाई किछि अन्य किछि टॉर्चर करूथिला कि कारण डाउरी कथा तो आपनकर सेई जा हितला सेई बाहागर बेले गोटे कोन स्कूटर मागिथिले तो वेयर इज दैट कंसिस्टेंट एविडेंस टू एस्टैब्लिश द प्रोक्सीमेट लिंक दैट कंटीन्यूअसली ये टॉर्चर करी चालीथिला एवं तार एई जो कंडक्ट पाई ही डिसीज्ड सुसाइड करिछि हला यदि if that is not there 498 is something different that's a but to link it with commission of suicide and which occurred after 7 years of marriage हला ये कहीं 7 वर्ष कहीं रखिले कहीं 8 वर्ष रखी पार थांदे 4 वर्ष रखी थांदे लेजिस्लेचर कोन पे उडे 7 वर्ष रखिला ये पाई ये चिंता कला जे जदि भी যৌতুক ନିର୍ଯାତନା ଗୁଡାକ ହୁଏ मैक्सिमम एई जाए जीव सेमान देखले तापरे पिला छुआ हेलानी से सब विषय अन्य कोन पाई पई पारबन तेणु से रखिले जे एई पीरियड भितरे जदि आसिला किसी निर्जा ये हला तापरे बट अगेन तापरे जदि टाइम गैप रही गला बट अगेन सम डिमांड अनलॉफुल डिमांड आसिला एवं जो कनेक्शन रे टॉर्चर हला एवं सुसाइड कला whether that would attract 306 or not that is to be seen कारण 306 रो 113A और 100 read it out
My lords. 113A, presumption as to abatement of suicide by a married woman.
duty a case re applicable
Lordship. When the question is whether the commission of a suicide by a woman has been abated by her husband or any relative of her husband, and it is shown that she had committed suicide within a period of 7 years.
Again, you see that period, 7 years.
7 years, yes. From the date of her marriage, and that her husband or such relative of her husband had subjected her to cruelty, the court may presume, having regard to all other circumstances of the case, that such suicide has been abated by her husband or by such relative of her husband.
Can this presumption be drawn at all in this case because of the passage of 7 years?
7 years period.
Definitely same ଜିନିଷ ଅଛି 113B କୁ ଆସୁନାହାନ୍ତି 113B ର wordings ଦେଖନ୍ତୁ.
Presumption as to dowry death. When the question is whether a person has committed the dowry death of a woman and it is shown that soon before her death, such woman had been subjected by such person to cruelty or harassment or in connection with any demand
ମାନେ ହେଇଥିବ ତାକୁ କୌଣସି cruelty obviously define ହେଇଛି 498A ର ଯୋଉ provisoରେ ସେଗୁଡା define ହେଇଛି cruelty ଟା କଣ ତେଣୁ ତାହେଲେ କୋର୍ଟ ପ୍ରିଜ୍ୟୁମ କରିବ it doesn't mean that 7 years ପରେ ଆଉ ଡେଥ୍ ହେଲେ ବା ସୁଇସାଇଡ୍ କଲେ କୌଣସି ଇଏ ପାଇଁ ମାନେ ଟୋଟାଲ ହବ ନାହିଁ ମାନେ that doesn't mean that 7 year pass କରିଗଲେ no one can be ତମେ ଯଦି wife କୁ torture କରିବ wife କୁ cruelty କରିବ ଏବଂ ସେ ସେଇଥିପାଇଁ suicide କରିବ it doesn't mean that you cannot be convicted under section 306 but it is a special presumption that is 113. So that is the distinction. But so far as main section is concerned, 304B, once 7 years gone, मैंने से offense ही जाइए, जोटा कि 306 रे नहीं, अर्थात 7 वर्ष परे मध्य कौनसी स्वामी यदि कौनसी कारण पाई जोड़ा cruelty definition आसीबो, harassment कला, torture कला, एवं ताकू that may be the reason which has abated that the commission of suicide, he can be also held guilty. So that is the basic difference. So what I want to say that you examine the evidence, hala, देखंतु जे ए जो proximate link जोटा कि हमें हार्प करूछु धर भी धरा जीवो जे ए circumstance suicide establish ହେଲା suicide କରିଛି କାରଣ accidental ये is ruled out, yes, homicidal is ruled out, so suicidal death ହେଇଛି जो circumstance ରେ ହେଇଛି ମାନେ ଗୋଟେ କିରୋସିନ ବୋତଲ ଇଏ ହେଇଛି ଆଉ ଗୋଟେ କିରୋସିନ ବୋତଲ ଅଧା ଇଏ ହେଇଛି ଏବଂ ମ୍ୟାଚ ବକ୍ସ ଅଛି so surrounding circumstance ଯଦିଓ doctor's evidence is not that categorical that it is a suicidal death and the Modi's jurisprudence also says that it is sometimes it becomes very difficult to ascertain that what is it all depends upon the factual scenario. So सेथिपाई ए टाइप रो केस रे साइंटिफिक ऑफिसर स्पॉट को विजिट करी मार्क करंती जे एटा को टाइप रो कोन ये रे पड़ीची हला तो मन करंतु गोटे जागा रे ता डेड बॉडी टा पड़ीथिवो बर्न इंजुरी हेइथिवो सेठी कोनोसी किरोसिन बोतल बा निजको पोड़ीवार किछि नाही ना मैच बॉक्स अछि ना ये अछि तो ता माने जणा पड़छि जे आउ को जागा रे ताको पोड़ा पोड़ी करिक नानी एठी पकई दिया जाइछि हला एंड अगेन ताकू जो जिनसटा गोटे जस्ट ताकू प्रोजेक्ट करिया पई मनकर ये किरो मैच बॉक्स पकाई थिबो गोटे मैच बॉक्स ता पड़छि बट मैच बॉक्स सी निजे जानी कि ये करथिले ये तो स्टिक था कौन था सेगुड़ा किसी नाई मैच बॉक्स यूज ही नथियो बा अन्य कोनोसी इनफ्लामेबल सब्सटेंस ही सेठी नाई सो दैट आल्सो क्रिएट्स डाउट जे नाई स्पॉट टा इटा नुए बट एई जगह से सुइसाइड करन इट डिपेंड्स अपन तेनु एठी आपन को स्कैन करिया को पड़िबो जे व्हाट आर दोज प्रोक्सीमेट लिंक which has been established by the prosecution even though we accept that I accept that it is a case of suicide ତେଣୁ ଯାହା evidence ଅଛି ଆପଣ ତାକୁ threadbarely analysis କରନ୍ତୁ ଗୋଟେ ହେଉଛି prior to the marriage ହେଲା demand of a scooter right ସେ scooter ର demand ପାଇଁ torture ହଉଥିବାର evidence କିଏ ଦେଇଛନ୍ତି ଏବଂ ସେଟା କୋଉ ପର୍ଯ୍ୟନ୍ତ ସେଟା ଆସୁଛି whether it continues till death if that is not there till death then what are the other reason the reason is that se jo kono pilata morigala pare ye कहला second marriage again for that also whether it was a continuous one or it was occasionally say type होउथला जोथि पई deceased asikini complain karichi ba whether there are other kinds of torture for any other reason, but materials are available. ये जो गोटे नोट करिकिन खाली एई लाइट रे PW1 एया कहिछि PW2 ए जो टॉर्चर विषय रे और डेट माने जदी डेट अछि बा इंसिडेंट अछि ताकू सेती खाली दियो माने दैट वुड बी हेल्पफुल हला से जो डिसीजन गुडा को କହିଲି ତାକୁ ନୋट କରି ରଖିଲେ ଗୋଟେ କାଗଜରେ ଟିପିକି ରଖନ୍ତୁ। ହଁ ନାଇଁ ଇଟ୍ସ ଅଲ୍ ରାଇଟ୍ ତାକୁ ସେ पेपर बुक रे लिखि दियंतु हला बाकी विल टेक अप दिस मैटर नेक्स्ट वीक
My lords.
गेट रेडी এই যে উপরে এটা পার্ট আউট করে দেবি না সপ্লিমেন্টারি আইटम 1 নেই আসবে হলা ଆଉ ଏଇଠି କୋଉଠି ଲେଖି ଦେଇଥିବେ ମୁଁ ଯେତିକି ଡିସିସନ କହିଲି ବର୍ତ୍ତମାନ ହେଲା ସେ ଏମ୍ ମୋହନ ଠୁ ଆରମ୍ଭ କରି ସବୁ ଗୁଡାକ ଲେଖିଦେବେ ହେଲା ନିଏ
Should come next Thursday.
next Thursday in the supplementary district will come as part out okay